Lordship is not off. Sitting with Justice Rai Chattopadhyay, your Lordship release the matter so that matter can be heard out this bench. This is your last order.
কি assigned?
Last order, এটা রেখে দিন।
Assignment টা দেখে নিন।
Grateful.
My Lord, Chief Millard, may I have appellate side mention? My Lord, Chief Millard, may I have permitted to mention an order 41. My Lord, urgencies, my Lord, on the 5th of August, my Lord, the executing court has, my Lord, kept the matter, my Lord, for, my Lord, executing a deed.
Of August, the regular bench is available.
His Lordship would sit, my Lord, I won't be able to, my Lord, get it listed on 5th, my Lord.
Yeah, impress the urgency upon his lordship.
Kindly, if this can be, my Lord,
What will happen if it is executed?
my Lord, deed will be executed, my Lord, the
What will happen if you dismissing?
This is a specific performance, so.
Yes.
But if the deed is executed and registered, my Lord, the title would get transferred. My Lord, it's a judgment of reversal, my Lord. I won in one court, lost in another.
কি করবি? অনেকগুলোই দিতে হবে। বেশি থাকে না। হলো দিয়ে দাও।
Lordship, may I have the liberty to mention a matter? This is a Section 37 appeal. The dispute between the parties is commercial in nature.
Yes. What do you want? Inclusion?
Lordship, I want it to be kept tomorrow because the next date before the lower court is tomorrow. As the dispute is commercial in nature, they have
Which?
filed before the non-commercial bench.
Very well. Heavens won't fall. Give it. It will be listed. It will be listed once the papers are available.
They are getting the interim order extended.
দাও দেখো লিস্ট দেখো।
Non-commercial matter. You will, sir, item number 1 and 2.
For the respondents here, my Lord, by an order of 19th January 2015, Honorable Justice Shonji Banerjee and Honorable Justice Shomati Chatterjee had directed us to file a bank guarantee. But the bank guarantee expired on was supposed to expire on 15 June has been extended.
Renewed bank guarantee by 50.
All I'm seeking today is one to leave to file the original bank guarantee.
You want to file it?
Well, I received it after 3 days. The bank guarantee has been renewed. I have to file it with the department. I need that leave.
Renewed in time?
Well, the bank guarantee is renewed.
Renewed.
The bank guarantee is renewed. Lordship will have a look at the bank guarantee.
No, what we'll look
It's
have a
come
look
from
at.
Kerala, my Lord. That's why it got delayed.
Wait,
Translate.
leave is granted. Leave is granted to order to Kochi. Leave is granted to learned advocate for the appellant.
No, my Lord, I'm the respondent here
Respondent
in the appeal, my Lord.
to file the renewed bank guarantee in the department
Grateful.
in course of the day.
The order may not be uploaded, my Lord, in the course of the day. If
In course of
Lordship
the
will
week.
endorse, if your Lordship
In course of the week.
I'm grateful. I'm grateful. I'm grateful.
Item number 3.
This is the matter we had mentioned for not seeking clarification of the judgment, my Lord, dated 30th September. Is the copy of the judgment, my Lord?
Item 3 perhaps has come up on the instance of the joint receiver.
Yes, my Lord. I am representing the special officers, my Lord.
May it please, my lords, I am appearing for the respondent in the matter, but I apologize for appearing virtually.
Why has it been listed?
My Lord, we are seeking
At the
an
instance
extension
the
of
special officers.
we're seeking an extension of time to comply with this order, my Lord. If my Lord comes to page 18, I'll hand up a copy of the order of the judgment, my Lord. Akshay. Page 18, my Lord. We were to carry out an inspection, my Lord, within a period of 1 month, my Lord. The last paragraph, my Lord. From the date of communication of this judgment, my Lord. It was
But
communicated
this order was passed about a year ago.
Yes, my Lord. It was communicated to
Yeah.
the special officers
We went
on the
before
7th
the
of
order
July,
was
my Lord.
7th of July.
This year, my Lord. It was
My lord,
communicated.
that's not factually correct because, my lord, we are defendants in the matter. My lord, we had intimated them way back, but they did not accept it because, my lord, it was their contention that this has to be intimated by the plaintiff appellants.
With leave of Mr. Bag, I am appearing for the purchase of the site at which the construction of my client is going on. We had communicated it by way of
Sir, do not go into the merits. We are not interested at the moment. There is an order which has not been challenged before a higher forum.
We had challenged unsuccessfully.
Unsuccessfully. So it stands. Let this be carried out at much time. We'll extend by 2 weeks.
Malad, I think they'll need some more time. They have to go to Thane and carry out an inspection, Malad.
Where is the land?
In Maharashtra, in
Where?
Mumbai, Maharashtra. Thane, Mumbai, Thane, Maharashtra, Malad.
Give 4 weeks. Lekho.
Malad, and just one other thing, Malad, the order directs 6,000 GMs. And the last 2 lines we paid to the joint special officers, Malad. Malad, we're seeking clarification whether this is joint special officers each or together, Malad, jointly.
The special officers are entitled to an initial remuneration of 6,000.
Must be each. Must be each.
That is the clarification, Malad, because
Who are the plaintiffs?
We are the plaintiffs, Malad. Our contention is.
Yeah, you are the plaintiffs. You are the plaintiff. Appellants are the plaintiffs. So at your instance, special officers have been.
No,
Of course.
We have not asked for taking.
Pay. Don't be miserly, Mr. Ali. An order was passed by a coordinate bench on September 30.
Only one thing, Malad. We had initially tried to pay them, Lordship, deducting TDS. Lordship, they had returned it. And of course, 3,000 GM we had paid each. Lordship, they are opposed to the idea of deduction of TDS. Lordship will kindly clarify that we have to deduct TDS.
Very well.
Lordship, may I take Lordship?
And you have paid 3,000 already. So further 3,000 returned.
They have returned.
clarification.
September, yes, September 30, 2024, the relevant portion whereof reads as follows.
No, please, senior.
এই অর্ডারটা পেজ 18 থেকে এই যে ব্র্যাকেট করে দিলাম paragraph. You appear for
For the joint special officers.
learned advocate for the joint special officers tells us that very recently the said order has been communicated to the special officers. Stop. Extension of time is prayed for to carry out the said order. Paragraph. We are also told that the said order was carried to the Honorable Supreme Court by way of a special leave petition by who filed this?
The plaintiff appellant and also the defendant, the purchaser,
by the parties, but such special leave petition was dismissed. The said order has attained finality and needs to be implemented. Stop. We extend the time period, the time for the special officers to carry out the said order by 4 weeks from date.
Some more time, Milord.
Why? Maharashtra is not outside India.
Large plot of land, Milord. Buildings have been
But
constructed.
4 weeks, how much time had been granted earlier?
There's also Ganesh Chaturthi.
4 weeks.
30 days was granted.
30, so by a month from date. By a month from date. Stop. We only clarify that, now we further clarify that the joint special officers will be paid initial remuneration of 6,000 GMs each, to be paid by the plaintiffs at the first instance, after deducting TDS. Anything else? That is all.
There were 3 special leave petitions. But
Doesn't matter.
doesn't matter.
This appeal is pending,
No, my lord.
disposed of. Oh, I see. Inspection to be report to be submitted before trial court.
It could call.
Yeah, good. What is it?
20.
Item number 4.
Lord, the matter is appearing today for extension of interim order. Lord, my application was under section 8 before the learned single judge for stay of the suit. Lord, that was dismissed. Lord, we came up in appeal initially. Lord, an order was passed. Lord, of course, directing the appeal to be heard
Not to transfer.
and not to transfer. Lord, that is, Lord, the order that your lordships had lastly extended. Lord, Justice Banerjee is sitting with Justice Rai Chattopadhyay after hearing the matter quite substantially. Lord, till the 31st. Lord,
The matter is running in the list.
yes, yes.
What number is that?
আজকে তো 4 নম্বর আইটেম কাল গতকাল দিয়েছিল
Oh, because there is fraud, therefore it can't be referred. Since we have not been able to, the interim order that is subsisting in this appeal is due to expire tomorrow. Kalke date ta diye deben. Paragraph. Since we have not been able to hear out the appeal, let the interim order stand extended till the end of August, 2025, or until further order. Shall we say till the disposal of the appeal, sir?
Yes, but kindly make it as if lordship can have a fixed time or date, Lord, whatever.
Till the disposal of the appeal. It is running in the list. We'll take up any day.
Very well.
Till the disposal of the appeal.
Take it. Very great.
The application, item number 5 and 6.
Malad, this is that application where Malad had directed the decree to be drawn.
Yes, what is the status now?
Malad, we have been circulated with the decree, Malad, yesterday.
Draft decree.
Objection, point number 8.
No, so that you take before the.
Before the court. I take before the court. I have taken it before the master also.
Take it before the master.
Yes, I have taken it. If
Yeah.
you not choose against us, I have a right before
That
the
you
court.
see later, not today.
Not today, of course.
Malad, there are
So we'll adjourn it for a
typographical
fortnight?
errors.
Huh?
A few typographical
That has to be
errors, Malad.
corrected by
Correct.
the
Now, whatever you do is before the master at this stage. So do we adjourn this for a fortnight
Malad, next week, Malad.
next week?
Take time, my lord. I have an objection. She has no objection.
Malad, I don't have any objection. Malad, there's only one typographical error.
Very
and
well.
this
Let it.
objection, Malad, have been
We have developed this habit of having this matter in the list every week. So let it be adjourned for a week.
much obliged, Malad.
আজকে কত তারিখ? 14th is way off.
Malad,
আজ কত তারিখ? 30th, 6th.
30th.
We are told 6th.
It has to be adjourned for a week.
We are told that the draft decree has been circulated amongst learned advocates for the. We are told that the draft decree has been circulated by learned master amongst the learned advocates of the parties. Stop. Paragraph. List this matter once again on August 6. একসঙ্গে হচ্ছে না আলাদা অর্ডার হচ্ছে দুটো একই সেম অর্ডার হবে দুটোতে
The death of one of the Malad, appellant number 2, Triveni. Malad, that order, Malad, had not been passed earlier because, Malad, we had mentioned, however, Malad, they had taken an objection on the entire petition, so this was not granted earlier. This is, Malad, order dated 17th October 23. So, my lord, we had placed that the recording of the death of Triveni Chaudhary had to be, my lord, taken place as appellant number 2. If my lord may kindly see the order dated 17th
We
October.
will pass that order when we dispose of the matter. We'll pass that order.
Much obliged, my lord.
Item number 7. My lord, I am for the petitioner. This is an application for restoration on 17th July. The matter was dismissed for default.
Reserved.
Yes, yes.
Restoration.
I could find. The only thing, my lord, your lordship will be amazed. Clerk concerned made a mistake, could not watch your lordship's list, and
My
there
lord,
is no explanation further why the advocates could not.
My lord, as well as we.
Not only that,
It is.
the client says it is true to my knowledge. My lord,
My lord.
I will be only visiting before your lordship.
Now, Nina.
And there is an injunction order, my lord, let it be restored also.
There is no injunction.
Yes, yes.
There is no.
Yes,
As
on
such,
20.
I am undertaking that I will not take any step. No injunction.
Uh,
No.
This is an application for restoration of APD 3 of 2024, which was dismissed for default on July 7. This was dismissed for default along with the connected application. Dismissed for default on July 17, 2025. Paragraph, having heard learned counsel for the parties, we are satisfied with the explanation furnished for absence of learned advocate for the appellant on the day the matter was dismissed for default. Paragraph, accordingly, the order dated July 17, 2025, is recalled. Stop. APD 3 of 2024 is restored to its original file and number. Paragraph GA 4 of 2025 is disposed of. That's all.
Interim order we restored.
Fixed time or date.
Time we can't. Let the matter be listed tomorrow itself.
My lord, the interim orders may be.
Where is the interim order? Yes.
No. Acha.
The order is recalled. So whatever it is now.
Obliged.
Number 8. So the only thing, my lord, instead of tomorrow, my lord, can it be on Monday? My lord?
Monday. Let the matter be listed. Let the appeal be listed. Monday did the.
Lordship, I appear for the respondent number 1.
8, who is for the appellant?
We are for the
Yes.
appellant. This is exhibit of service. This is for the application for restoration of the application.
Restoration affidavit হয়েছিল. Affidavits have been filed in the restoration application.
Opposition and reply.
There was a delay in filing of the restoration application. If my lordship looks at the last order, lordship had condoned the delay, but had directed us to file opposition. Lordship.
And to the opposition, we have filed a reply. My lord, there's a very opposition has no substance. They are charging that there's a delay in filing of the appeal of 12 years, which has been already admitted. If the file is restored and file is restored, they will not be prejudiced by any means. It is the appellant who will be prejudiced.
You applied after 12 years.
That is admitted, my lord. My lord, kindly see the order. My lord, kindly see the order dated 7th February 2024, where the appeal was admitted. Appeal was admitted by this honorable court, and substantial question of law was also found. This was
In restoration application, we are definitely not deciding the merits of the appeal.
deeply obliged.
So therefore, let us restore, sir, be reasonable. We'll hear out the appeal immediately.
This is not on merit, my lord. I'm deeply obliged.
If I may point out, I'm appearing for the respondent number 2.
कोई बात नहीं जज साहब
To
को
the
बताए
prayer
तो
portion at page 4 and 5.
ज्यादा जरूरी नहीं है तभी तो
जब अपील में बताइएगा।
ज्यादा बोलना मुझसे ज्यादा अच्छा नहीं है
The lordship feels
to allow this, that can be allowed, I won't raise any further objection because multiple prayers have been clubbed together.
No, no, no.
My lord, deeply obliged.
Here.
Deeply.
When will you do the appeal? Tell us.
My lord, any day as my lord can.
Sure.
My lord.
Sure.
You must be not imposing the interim order.
My lord,
No,
no,
yes.
We are
interim-
recalling the order.
My lord, there is an interim order. Interim order maybe, maybe.
And your lordship बोली जिस दिन ये order पहला दिन ही था मैं नहीं गई.
This is an application for restoration of APO 17 of 2024, which was,
prejudice.
this is very bad practice, madam. When one dictates, you're obliged.
I apologize, my lord. I apologize.
Restoration of APO 17 of 2024, which was dismissed for default on April 21, 2025. Paragraph, having heard learned counsel for the parties, comma, although we are not fully satisfied with the explanation furnished for absence of learned advocate for the appellant on the day the matter was dismissed for default, comma, taking a lenient view and for the ends of justice, comma, we recall the order dated April 21, 2025, comma, upon the appellant paying costs assessed at. Do you want a legal aid, legal service?
My lord, we were deep. No, my lord, we were deep.
No, normally I don't make this prayer. But
You're representing Mr. Pasari.
My lord, we were sick. My lord, there is a report, my lord. On that very day, I had a MRI of the eye.
The advocate may be in difficulty.
MRI of the eye.
Upon your condition, now recalled, huh? Paragraph. Accordingly, comma, APO 17 of 2024 is restored to its original file and number. Paragraph. GA such and such 2 is disposed of. Stop. However, comma, the interim order of status quo shall continue only till the end of August, 2025, or until further order, whichever is earlier. Paragraph lists the matter. Eta ki appeal from decree, ki eta appeal from order, under the appropriate heading within the first 5 items. Friday?
Friday.
Porshudin.
Grateful, deeply obliged.
Monday.
Monday, grateful, my lord, deeply obliged.
item number 9.
Yes.
May it please your lordship. Lordship, this is my appeal. On the last occasion, your lordship, the appellant was substituted and the department has carried out the correction and has come back. Lordship, in the meantime, there's one more defendant who has passed away.
Boju.
So, your lordship, I have already filed it. It hasn't come before your lordship.
What is this GA appearing in the list?
Lordship, this is for stay of the original appeal.
Then give the number. Hey, a substitution file.
Lordship, it has been filed in the department yesterday. It will come. Lordship, kindly make it not this week. Next week we can have it done.
We are told that yet another defendant has passed away during the. Then we will not take up the matter. Why are you so worried? Without service, we don't take up. He yet has passed away during the pendency of this appeal. Top learned advocate for the appellants says that an appropriate application for substitution has been filed in the department. Stop. Let that application be listed along with the appeal on Monday date. Stop. Service of that application be made on the learned advocates for the respondents. Wednesday week. Wednesday week, na, sorry, next Wednesday.
Next Wednesday, your lordship. I'm grateful, your lordship. Which 9 and 10 the same order.
9 আর 10 একই order করে দেবে। আলাদা হবে কিন্তু same order.
Same order.
Item number 11.
My lord, I am for the appellant. My lord, I am sorry, my lord, I am little handicapped today. By mistake, my brief has not come. Kindly take it up tomorrow. I'll do it in the morning.
Not today.
আমার ব্রিফটা আসছে রাস্তায়
Item number 12, my lord, I am for the appellant, my lord. My lord, I will be very candid enough, my lord. What has happened, my lord? I have served my notice of motion, my lord. We have not, my advocate on record has not served to the respondent because previously there was a direction of by the coordinate bench that the matter shall be heard ex parte. Thereafter, the matter had appeared before the learned trial court. Over there, the learned judge had asked us to serve them and come back. We served them, they did not appear, and then after the impugn order was passed. So based upon the order of the previous division bench, my lord, we have not served them because the matter was supposed to be heard ex parte. If your lordship says we'll serve them, my lord. My lord, may kindly see page 77, my lord. The previous orders from which we had again went to before the learned trial court.
Serve and come back.
My lord. Lordship may kindly keep it on next.
Learned advocate for the appellant says that service is not complete. Paragraph, let service be effected on the respondents and affidavit of service be filed in court on the next date. When?
Wednesday, ma'am.
Paragraph, as requested by learned counsel, comma, let this matter be listed again on Budvar.
6th. I'm grateful, ma'am.
Number 13. Number 13, my lord, I am for the appellant, my lord. The appellant does not want to praise this appeal.
That is excellent news. We don't want to know anything more. Do you have any written instruction? No.
No, my lord, already complied. The order has already been.
Acha. Lekho, learned advocate for the appellant says that he has instructions not to press this appeal since, not to press this appeal. Paragraph, APOT such and such is accordingly dismissed. Stop. Interim order, if any, stands vacated.
Deeply obliged. Item number 14.
My lord, I appear for the appellant. I am being led by Mr. Tilak Bose. I have been requested to take a passover. He is stuck in traffic. He is.
Thing is, to cut the matter short, they have a condemnation of delay application, 11 years delay.
Only?
Only.
No, I
So
know they
therefore,
will file an
let us do
affidavit.
the affidavit to
Just that I didn't want Mr. Bose not to be here. If
Mr.
lordship can-
Dattu, we have to give direction for
Very good, very good.
affidavits.
I leave it here.
How many days is that?
My lord, I come to know of these, my lord, my challenge. When I move my application with the leave to appeal, my lord, lordship will understand that this 11-year period will not, length of delay is not what is important, my lord. The explanation will be, my
All
lord.
right. Isha, Ashok. Which one is this? Condonation application is which one? GA?
GA2 is section 5, my lord.
And GA, why
GA,
3?
my lord, GA1 is, my lord, leave to appeal. Because I am not a party to the suit, my lord, a party to the proceeding in which, my lord, the order was passed and I'm challenging that order. I took leave from
We have to first allow GA1, otherwise even on condonation we can't give.
So GA1 also, we have objection, we have to use an opposition.
Well, let him file affidavits in GA1 and GA2.
1 and 2. GA1 and GA2 te. GA1 is an application for leave to file appeal since the intending appellant was not a party before the learned single judge of this
Yes,
court.
executing court, single judge.
Single judge, stop. GA2 of such and such 2025 is an application for condonation of delay of about 11 years, of more than 11 years in presenting the appeal. Paragraph, learned advocate for the all respondents you appear.
Respondent number 1.
For the respondent number 1.
Respondent is 1.
Says that his client would like to file affidavits in opposition to the two applications. Paragraph, let affidavit in opposition be filed 2 weeks.
3 weeks, because this is 11 years.
Within 3 weeks from date ta diye deben. Stop, reply thereto, comma, if any be filed within
2 weeks.
2 weeks thereafter. Paragraph, list this matter once again.
All the points, including maintenance.
once again, 5 weeks hence, whatever data din, paragraph, at the instance of learned advocate for the respondent number 1, comma, the point of maintainability of the applications of the appeal and the connected applications is left open.
Grateful. Well, I made that submission because I was requested to. Otherwise,
No, we understand. We understand. Yeah.
Item number 15.
My lord.
My lordship.
Hello. My lord, in the instant. My lord, in the
My
instant
lordship,
matter.
I am the petitioner in person. My lordship, in brief, the facts of the case is
My lord,
the respondent.
My lord, my counsel appearing in the instant matter is unable to be present today. I am instructed to take 1 day's adjournment, my lord.
My lordship, there is an urgency in the matter. A stay be granted.
You are a learned advocate yourself.
Yes.
Your learned brother who's representing the respondent is in difficulty.
Yes, my lordship.
1 day's accommodation is sought.
Only a small stay of
Small
the stay of the impugned order.
Small, how small?
Tomorrow.
How small?
My lord,
Small stay, you said. How small? Hey,
for tomorrow, only for 1 day.
Order down. That's all.
The impugned order is at page 124.
My lord, we have already received documents from Appello.
You have asked for revocation of the probate.
Yes, my lord. And its stay has been granted, and the Honorable Single Judge below has directed the propounder of the will as well as the applicant to restrain from any sorts of transfer, exchange, any encumbrance, any changes whatsoever of those assets which are mentioned in the will. So now at this stage, when my pleadings are incomplete and further directed to file affidavit in opposition, which they have already filed, and my reply was due on 29th, I had filed it on 29th. At this stage, on 18th July, they have moved this application. In the application, they have mentioned that this application is the outcome of the revocation. But at the time of argument, they said that they want to make reimbursement of the medical expense and prepare the accounts and the estate of the deceased. My lordship,
We have already
Honorable Single Judge below has allowed them my humble submission at that point of time that allow me to file an affidavit in opposition. He has given me 7 days time and reply to them. But an interim order has been passed to hand over the bank documents and the medical documents, which the alleged executor is not supposed to get as per the last wishes of the testatrix. So my humble submission was not to pass any interim order. Kindly hear my affidavit in opposition, and they reply and thereafter pass the order. But within 7 days, that order was passed. So within 3 days, I had filed this appeal, and I have also filed the affidavit in opposition on the very next day on Monday. Our matter was heard on Friday. So there is an urgency in the matter.
My lord, kindly keep
let
it tomorrow. Let Mr. Dutt address it on.
The stay of the operation be given till
My
tomorrow.
lord, may kindly keep it tomorrow. We have already received documents from Appello.
Come back tomorrow, sir, not today.
My lord, one indulgence, can it be fixed tomorrow? Because tomorrow is not the original side matters will be taken up.
After exhaustion of appellate side list, and tomorrow is another day. Who knows what happens? Let us see. Come back tomorrow.
Okay, much obliged.
Should I appear for the appellant? The matter wherein, my lord, lordship may remember, my lord, there was a consent decree, an eviction suit.
Justice Apurvo se there hai.
Yes. When the execution was filed.
New tenancy.
Yes,
That was the
new
learned thing.
tenancy. And, my lord, in fact, the tenure of the consent decree has also expired.
Yes, just recapitulate very briefly. We'll hear the other side then.
Yes, my lord, suit for eviction file ultimately, my lord, boils down to a consent decree.
You were the plaintiff.
I was the plaintiff. In the consent decree, my lord, the portion, my lord, let us take it 100 square meters was reduced to 80 square meters. And, my lord, a term that they will, my lord, hand over possession after the tenure is over of a period of 10 years. And if there is any violation of the provisions of the Premises Tenancy Act. This is the consent terms. So, my lord, accordingly, they had a problem with the tenant, my lord, with the consent terms. They filed an execution application prior to us. And, my lord, there was an order passed by this court.
They filed an execution for what? I mean, I'm praying for what?
There was, my lord, a demarcation issue, and also they filed an execution application regarding the same consent decree. Obtained an order from this court. And accordingly, the order was executed also. Now, my lord, they, my lord, started, my lord, not paying rent, in the sense that, my lord, they started paying rent through a person who is not the tenant. Now, my lord, we objected because obviously, my lord, I cannot create a third party right by accepting rent from a person I am not known or not authorized even. There is no document even authorizing such person to pay rent on behalf of X and Y. In view of this, my lord, we filed, my lord, the execution proceeding, my lord, to execute the decree, the consent terms. At this moment, my lord, they come up with a new case saying that this is a new tenancy and therefore
There is no such opposition or a
they come with a new case, my lord, that this is, my lord, a new fresh tenancy. And, my lord, therefore, it is not executable. Now, the best part of it is that, my lord, this is a submission from the bar. There is no such pleading in their opposition. In execution, an opposition is allowed to be filed. And, my lord, there is no such pleading with regard to this submission in the opposition. And, my lord, they say they are continuing in possession of the said premises. Now, my lord, the question is that, which fell, my lord, from the earlier bench taking up this division bench, my lord, is that by this time also, the tenure has also expired of 10 years. So,
when was that consent decree passed?
This consent decree was passed
2014.
23rd of June 2014. So, my lord, today, even if we don't look at anything, my lord, as it is, my lord, he is supposed to hand over possession to me. Either way, because, my lord, the tenure of the entire proceeding, my lord, or the, my lord, term for which, my lord, he was to be a tenant in respect of the consent decree or otherwise even, has also come to an end.
Yes, but the case that he's running, that there's a fresh tenancy, whether firstly he should be permitted to run that case.
Absolutely.
Secondly, if he's permitted to, then is there anything to show a fresh tenancy?
Nothing except the consent decree that, my lord, the portion has been reduced. That is all. Kindly seize two paragraphs of the consent decree. Lordship will, my lord, be able to, my lord.
Page 20.
Volume 1 है ना?
हाँ, volume 1, page 20.
Well, kindly comes to page 21, volume 1. This is the terms of settlement, my lord. Kindly, my lord, takes page 20, page 21, because my lord, this will show the, my lord, portion, the tenant. Terms of settlement.
Page 44.
45. Next matter.
Yes.
Kindly comes to page 21, my lord. This is the terms of settlement before I show the decree, my lord, agreed upon by the parties. But kindly sees paragraph 1 itself, the tenancy of the defendant as per the agreement dated 7th May 1971 in respect of one shop room, number 1 capital A, on the ground floor at premises number 30 Ganesh Chandra Avenue, Kolkata, measuring about 1014 square feet built up area. Now, my lord, sees thereafter simultaneously with such surrender of said tenancy to the plaintiff as stated above, plaintiff landlord shall and induct the defendant as the monthly tenant in respect of all that shop room number 1 capital A oblique 1 measuring about 507 square feet, being 50% of room 1 capital A. So, my lord, 1 capital A was 1014. It has now become automatically, my lord, 1 capital A oblique 1, my lord, 507 square feet. Because obviously, my lord, it won't have 1 capital A. And this is what it takes advantage of. On the ground floor, measure same premises number 30 Ganesh Chandra Avenue, Kolkata 13. More fully shown and delineated in red color in plan and sketch map such and such. The said shop room being number such and such shall contain a toilet, and the rest are the same.
Objection to the
Yes.
Now, my lord, kindly comes to page 24, paragraph 7. Lord, since 1 capital A was divided, my lord, each of 507 square feet. So, my lord, kindly sees the area being room number 1 capital A by 2 at measuring about 507 square feet together with porch of the building shall remain in exclusive possession of the plaintiff landlord. So, rest of it has come back to me. This is agreed by him. Now, my lord, kindly sees, my lord, the paragraph which is most important, paragraph 9, page 25. This is with regard to the area. Now, my lord, kindly sees the tenure.
It's commercial.
It's a shop room commercial, yes. The name and style and status of the tenancy shall remain in GC Seal and Company. So they are the tenants only, nobody else. As proprietorship firm of the defendant Govindo Chand Sheel as usual and for a period of 10 years without any alteration and or amendment. It is agreed and made clear that the said tenancy will not be terminated prior to the stipulated period of 10 years, provided the terms and conditions as stipulated herein and also the grounds as provided in West Bengal Premises Tenancy Act 1997 are complied with strictly by the tenant. That is all. This does not, my lord, in any effect gives right that, my lord, it is a fresh tenancy by, my lord, recording this particular word that, my lord, terms and conditions as stipulated herein in grounds provided in West Bengal tenancy. In fact, my lord, this, my lord, only gives us that, my lord, he should not be evicted in by any other means, but in accordance with law. And that is by way of an execution. Now, apropos this, my lord, kindly takes the decree. And there's one more line, my lord. Yes. At page 25, the same paragraph 9, it is agreed that at the expiry of 10 years from the date of these terms of settlement, the defendant shall hand over peaceful vacant possession of the demised premises to the plaintiff. So, my lord, kindly see 25, paragraph 9 towards the middle, my lord, just after that. It is agreed that at the expiry of 10 years from the date of these terms of settlement, the defendant shall hand over peaceful vacant possession of the demised premises to the plaintiff. So, my lord, leave apart everything. Today, my lord, this time period is also over. And he was in possession, he is in possession still. Now, my lord, kindly sees apropos this, the decree which was drawn up, my lord, the consent decree, that's at page, my lord, 45. It starts from 45. My lord, kindly takes the relevant portion which they are, my lord, taking advantage by showing that this depends on the terms of settlement. My lord, kindly comes to page 49, my lord. My lord, if I may read from 48 itself, because the sentence starts from there, my lord. Just 48 from the middle, my lord, and the parties having agreed to the terms, lordship has got it, terms of settlement out in the schedule hereunder, it is declared with the consent of the parties by the signature of the plaintiff himself and that of the advocate, and also by the signature of the defendant himself and that of his advocate, and the said terms of settlement be recorded and ought to be carried out, and the same is ordered and decreed accordingly. And the plaintiff such and such will be at liberty to apply for withdrawal of the rent that already was deposited with the registrar original side. All interim orders already passed in the suit and the same are vacated. So therefore, my lord, what they say now is that in view of the decree being drawn up in terms of the settlement, my lord, and because of that, my lord, line being there, it is a fresh tenancy. Most importantly, my lord, even if I give up everything, the consent terms only say that after the tenure is over, he has to hand over possession back to me. Today, my lord, the tenure is admittedly over. And one kindly sees their opposition, which is at page 109 of, my lord, volume 1. Hundred and nine, my lord.
This is the affidavit in support of your execution.
Yes. Affidavit in opposition, filed by them in execution.
Opposition.
অন্য পয়েন্ট ছিল কেন?
47 to correct. There is, my lord, no section 47 application, my lord. So, my lord, unlikely an opposition and in execution should not be allowed. But, my lord, be that as it may, this is an opposition, not a section 47. Now, kindly sees, my lord, 110, 10, my lord, paragraph 4. What is the case now he runs? The judgment debtor states that any compromise decree passed in a suit for eviction of a tenant without proving any of the grounds alleged in the plaint and without deciding one of the issues framed, which would make the tenant liable to be evicted under the statutory provisions of law, would be in contravention of the statutory provisions of law. As such, the said compromise decree would be without jurisdiction and nullity. So if he says nullity, my lord, then he had to file a section 47. And this is a compromise decree which he has taken advantage of by filing an execution himself. And he, my lord, has acted in terms of this decree. Till the date that he has paid rent correctly, he has acted.
Earlier application with Justice Showmanship passed an order we see in 2015.
Yes.
That was his application.
No.
That was your application.
My application. That was my application. Now, my lord, kindly sees paragraph 8. Very important, my lord, paragraph 8, 111. It is stated that since the said terms of settlement and judgment and decree dated 23rd June 2014 passed in the suit number such and such, both are hit by the relevant regulatory provisions of law. As such, no equitable relief can be claimed. That is therefore most humbly further stated that since on the teeth of an earlier execution case, the judgment debtor has been parted from his rented premises on the strength of terms of settlement made against the relevant statute. And since the said judgment and decree is inexecutable on the ground of nullity, is entitled to restoration of possession of the portion of his rented premises wherefrom he had been parted.
Don't think. Absolutely.
So this parting.
So he wants back that portion also now.
Yes. This parting then becomes, my lord, he has been 501. So the rest he has been taken away. He's been parted. So this is new tenancy.
No place of new tenancy.
And apart from this, there is no case of new tenancy being made out in the entire, my lord, opposition.
Let us hear, Mr. Kaur.
The only thing I'm saying, my lord, today, without going into this nitty-gritty, my lord, terms of settlement record to hand over possession post the tenure is over. The tenure is long over, my lord. Very well.
Clarify on the point of law which we had argued. And I am one judgment 1981 SCC 185. This is a judgment which has been annexed to my written notes.
Execution.
Find it from page.
Signed before the learned single judge.
We have a file notes, my lord. Before
Here before us.
Not before.
Coordinate bench.
Coordinate. We had filed.
For starting it, I'll just indicate why we came up with this. Lordship, today, the circumstances for settlement happening in the course of proceedings. Lordship, I'm sorry, my lord. Lordship, in the present case, Lordship, in the present case, the settlement was arrived and a decree was passed on the basis of it. So the consideration for the court in the Supreme Court judgment as well as the other judgments following it were whether the settlement was in aid of execution of a decree or whether it created a fresh tenancy. Now, there were two considerations which were made. That was the stage in which the settlement was made. If the decree is passed on the basis of the settlement, then it creates a separate tenancy. But if the settlement was made at a subsequent stage, post passing of the decree, and at an execution stage, it was held that it was in aid of execution, and as such, whatever be the decree has to subsist, and the execution has to be on the basis of it. The decree cannot be nullified by way of a settlement in execution proceedings. I will just place the first judgment, which is 1980, Volume 1, SCC 185. Lordship, I'll just place a bit of the facts because over here also a settlement was arrived at. If your Lordship takes under a registered lease deed dated 11th September 1948, respondent number 3, who is the managing director of the appellant company, took the suit premises, being a theatre, on lease from respondent number 1 for a period of 5 years commencing September 1st, 1948. During the period of the said lease, respondent number accepted rent from the appellant company at the rate of 2,000 per month and thus accepted the appellant as tenant. On the expiry of the period of lease in 1953, respondent number 1 and 2 filed a suit for ejectment against the appellant. And the appellant also made an application before the Rent Control and the West Bengal Rent Control Temporary Provisions Act 90 for fixation of standard rent. Ultimately, a compromise was arrived at between the parties and a consent decree, kindly mark this, a consent decree, it was not in execution, was passed providing inter alia that the appellant company would be the tenant of the suit premises at the rate of rupees 1,000 per month from March 1995 for a period of 5 years, and that at the end of the 5 years, there shall be no renewal of the lease. Lordship, similar terms and conditions to what our terms of settlement provides. I will not trouble your Lordship with the rest of it. Kindly come to 3 issues which were framed before the Supreme Court. Your Lordship will find that at page 16. Lordship will find the following 3 questions arose before the Supreme Court. What with the status and nature of possession of a person who was admittedly a tenant of premises covered by the Local Rent Restriction Act till the date of commencement of a fresh lease, which turns out to be void for want of registration during the expiry of the period purporting to be reserved by such a void lease. Could such a person be a tenant who could only be removed by proper legal proceedings or a licensee without any interest in the premises and could be forcibly evicted by the landlords of the premises, entering the premises and locking the same? Could such a person, this is second issue, is what really concerns us. The third issue was, could such a person defend his possession by a suit seeking a declaration and mandatory injunction? Lordship, the response to the second query is actually in paragraph 5. Lordship, I will take your Lordship directly to paragraph 5, which will be at Lordship internal page 20. Lordship, page 21, I believe, of the compilation. But the questions that emerge for consideration in the appeal are, what would be the status and nature of possession of a person who was admittedly a tenant of premises covered by the Local Rent Restrictions Act till the date of commencement of a fresh lease, which turns out to be void for want of registration during and at the expiry of the period purporting to be reserved by such a void lease. Could such a person be a tenant who could only be removed by proper legal proceedings or a licensee without any interest in the premises and could be forcefully evicted by the landlords of the premises, entering the premises and unlocking the same? Could such a person defend his position by a suit seeking a declaration and mandatory injunction? Your Lordship will kindly see this question is answered in paragraph 17 of the same judgment. Your Lordship, but before taking your Lordship to paragraph, kindly take paragraphs 6 and 8. I'll just read it. Appellant was accepted as tenant by respondent number 1 and 2, even though the indenture of lease dated 11th September 1940, executed, referred to as the first lease, was executed by the third respondent, who was the managing director of the appellant company. Indisputably, when the first lease expired on August 31, 1953, the appellant was the tenant of the demised premises, a fact demonstrably established and accepted by respondent numbers 1 and 2, and evidenced by their conduct of accepting rent from the appellant company, identical to our case. We have been inducted, we have paid rent, they have accepted the rent. No dispute. And there is no default. The default which is in question is a default which they claim that we were tendering through somebody else. That's also incorrect. They did not accept the rent. We submitted under section 21 of the West Bengal Premises Tenancy Act. Not sure, once the rent is tendered under section 22, there is a bona fide tender, and that cannot be challenged that we have not paid the rent. We have paid the rent, but only before the appropriate authority, that is under section 21 of the West Bengal Premises Act. Lordship, coming back to the judgment, the indenture of first lease granted an option of the to the lessee, which would be none other than the appellant company to claim renewal of lease. The option was not exercised. Notwithstanding the non-exercise of the option on the date of expiry of the lease, the contractual tenancy having come to an end, the tenant would be a tenant holding over if requirements of Section 116 of the Transfer of Property Act are satisfied. However, on the date of expiry of contractual tenancy, the West Bengal Premises Rent Control Temporary Provisions Act 1950 was in force and was applicable to the premises, and therefore, on the determination of contractual tenancy by a flux of time, the terms and conditions of lease are extinguished, and the rights of such a person remaining in possession are governed by the statute alone. He is loosely described as statutory tenant, which is another name for status of irremovability. In paragraph 8, by the consent decree, appellant and respondent number 1 entered into a fresh lease for a period of 5 years. The High Court has found this lease to be void for want of registration, and this position was not disputed before us. The appellant, Lordship, this is again the second lease which was entered by way of a terms of settlement, which I just placed in paragraph 1 in the facts. During the pendency of proceedings, a compromise was entered into and the lease was executed for a period of 5 years, allowing the tenant to continue for a period of 5 years. So that is the lease that had not been registered. Since it was not registered, it was held by the court below that the tenancy was void because it lacked registration. So that is what the Supreme Court was also considering, that even if it's a void tenancy, what would be the consequences?
Not void tenancy, void lease.
Void lease, I'm sorry. Whether it was a licensee or a lease. So if the lease goes, they become a licensee. Actually, the appellant continued in possession for a period of 5 years and paid rent as agreed to between the parties in the consent decree. So this is as per the consent decree. Now, if the lease is void for want of registration, neither party to the indenture can take advantage of any of the terms of the lease. At best, the provisions contained in Section 53A of the Transfer of Property Act, which incorporated the English equitable doctrine of part performance, can, if the terms thereof are satisfied, be relied upon to protect possession of the period reserved under such a void lease. But no other terms of such an indenture, inadmissible for want of registration, can be the basis for a relief. In this case, respondents 1 and 2 rely upon provisions in the consent decree that there was not to be any further renewal of the lease, and the High Court was so much impressed with this provision when it observed. The observations, the last 3 lines are really, but I'll read anyway. Here is a party who has solemnly entered into an agreement, has enjoyed the benefit of it, has committed a flagrant breach of it, and now wishes the law to come to his aid and protect him from the evil consequences. If the appellant succeeds, it will be a most unhappy state of affairs. The observation appears to be provoked by the High Court looking into that part of the consent decree which provides for no further renewal of the lease, which, being a term in an indenture inadmissible for want of registration, could not have been looked into, and this feeling of righteous indignation completely ignores the overriding provisions of the relevant Rent Restrictions Act, which came to the aid of every tenant in its area of operation on the determination of contractual tenancy. As its commencement, every lease would have its origin in a bilateral contract, which, except for lease for infinite period of permanent lease, would be for some specified duration. On the expiry of the period, the solemn implied promise or assurance is to return possession. If such a promise is to be enforced, overlooking or ignoring Rent Restrictions Act, it would make a mockery of protection extended by Rent Restriction Act.
Please document. The decree.
In terms of the existence of they have just extended the term. Yes. Very good.
Thereafter, kindly take paragraph 10. If, as it clearly transpires from the facts of this case, the appellant was a tenant on the date on which the second lease, which is found to be void, was to commence, that would be the nature of possession of the appellant during the period of 5 years. Lordship, identical to us, we were a tenant till the passing of the decree and till the passing of this consent which was given, the terms of settlement which was executed, we are a tenant on that date.
But no fresh lease deed was executed, as in this case.
This case, it was a void lease. In our case, we have continued as per the terms of settlement.
No, but again, won't that be a distinguishing feature that in our case, there was no fresh lease deed? In Bishubani, there was a fresh lease deed which was found to be void for want of registration.
It says that even if it is void, but this is where it comes, this paragraph, that although it is void, we have continued in possession, the landlord accepted the rent, and we have continued tendered the rent, and that creates a fresh tenancy. And because of the tenancy, we will be covered under the Rent Act and cannot be evicted without due process. Yes, your lordship is talking about it be a licensee because the lease was over here. We do not have any document apart from the terms of settlement.
Is the decree?
But the decree is of induction, not of eviction.
Decrees of continuation, extension of your possession. Decree only extends the duration of your possession. It's not fresh induction.
The terms of settlement records that I shall vacate and I shall be inducted. So it's a fresh induction. The decree is of an induction for a period of 5 years in respect of a premises for a rent. Kindly take the terms of settlement. Lordship, the terms of settlement is at page 20.
You will vacate 1A and you will be inducted in 1A by 1 or something like this.
So it's their suit is for eviction. That stands satisfied the moment I vacate the suit premises. But what happens in the meantime, which is what also happened to Bishamani, they entered into a settlement. The distinction I understand, Lordship, that there was a deed in the case of Bishamani. We do not have a deed.
Stirred. If you run your case that high,
I have to
otherwise to distinguish.
the terms of settlement, my lord, page 22, clause 2, I surrender.
Even if it is a fresh induction, parties agree. You are settling a dispute which is before the court. You are telling the court that these are the terms. On your agreeing to vacate after 10 years, you are allowed to be there for 10 years. Now, should you be permitted to turn around after 10 years and say, sorry, I am protected by the Rent Act?
That is what this judgment says. I will just continue with the judgment because this is exactly paragraph 10. This is the provision which they deal with.
Very well, you place your case, yes.
If, as it clearly transpires, Lordship, paragraph 10, as it clearly transpires from the facts that the appellant was a tenant on the date on which the second lease, which is found to be void, was to commence, that would be the nature of possession of the appellant during the period of 5 years. The period sought to be reserved under the second lease, and on the expiration of such period, if the appellant was put into possession for the first time under a void lease, the appellant could have protected its possession under 53A, but it must be made distinctly clear that the appellant was not in possession on the date on which the second lease was now found void was to commence. Would this attempt incoherent or stillborn of entering into a fresh contractual tenancy making any difference in the position of the appellant and the nature of his possession? If the second lease is void or incoherent or ineffective or stillborn, it is not at all effective. If it is not effective, it does not find upon the nature of the appellant's possession, which was that of a tenant. In other words, the appellant continued to remain in possession of the demised premises as tenant because there was no impact of the lease which is found to be void. It must be made distinctly clear that the appellant was not put in possession under the lease which turns out to be void. In such a situation, even during the period of 5 years for which the second lease was to be created, the appellant continued to be in possession as tenant, and this is evidenced by the further fact that rent was accepted from the appellant by respondent numbers 1 and 2. There is nothing to show that the rent was accepted from month to month by respondent numbers under the second lease and not what was determined by the court. In rent fixation case number such and such, wherein the parties had filed a consent by which the parties invited the rent controller to fix the standard of rent. Lordship will straightaway come to paragraph 11 thereafter. Even if it is assumed that the appellant was put in possession for the first time under a lease, which turns out to be void, the appellant came into possession of the premises with the consent of the landlords and paid rent from month to month. As the lease was to be for a period of 5 years for want of registration, no operative lease came into existence. In almost identical circumstances, Lordship, it refers to other judgments. Then kindly come to paragraph 17. But you will find it at page 29.
There's a code. Yes.
Paragraph 17. If the appellant thus continued to be a tenant, it could not be forcibly evicted if the premises enjoyed the protection of the West Bengal Premises Tenancy Act 1956, which was in force on 29 February 1960, which accorded to respondent numbers 1 and 2, the period reserved under the void lease expired. Respondent number 1 and 2 cannot, ignoring the provisions of the relevant restriction laws and merely treating the appellant as licensee or trespasser. Trespasser is also included over here, ignoring its status of irremovability.
Yes.
Take over forcible possession. In such circumstances, the appellant as tenant would be entitled to protect its possession unless evicted in due course of law. In order to protect its possession, it can legitimately sue, there being no bar in law for a declaration of its status as tenant and for an injunction, either prohibitory or mandatory as the case may be. The High Court really missed the core problem and with respect misled itself into invoking the provisions of section 53A, which the learned counsel appearing for the present appellant declined to invoke in its favor and came to an unsustainable conclusion that under the consent decree, the parties agreed that the old tenancy would be wiped out and a new tenancy would be created for a period of 5 years expiring in February 1960. A stillborn attempt not clothed with legal formality cannot destroy the existing status, but you will kindly mark this. The second lease never came into existence for want of registration, and more particularly, the appellant was not put in possession under the purported second lease, which turns out to be void. The paradoxical approach manifested in the approach is that if a valid lease had come into existence on the expiry of it, the appellant tenant would have continued in possession under the protection of the relevant Rent Restriction Act. However, if such an attempt at creating a fresh lease was ineffective or infructuous, how can such an inchoate exercise destroy the existing right, which the High Court held to have been destroyed, ignoring the very existence of West Bengal Premises Tenancy Act 1956? The High Court was further in error in holding that if on the expiry of the agreed period of lease, there was a covenant for not getting any renewal of the lease, the tenant would be a trespasser, wholly overlooking the legal position as affirmatively established that on the expiry of the contractual tenancy, the tenant continues as a statutory tenant except when he surrenders possession or is evicted under the enabling provisions of the relevant Rent Restriction Act. there is no decree of eviction over here against us. The decree was a consent decree by which I have been inducted. Lordship,
Evicted and inducted in a portion of what you held. You have been removed from what you held, 1014, and then inducted. So that is the eviction. And inducted in respect of half that area, 507. Now, if the decree contemplated that, if the agreement of the parties, which became the decree of court, was that the parties shall enter into a fresh lease, and if such a lease document was executed for 10 years, not registered, you would squarely be covered by Vishwavani. But in the facts of the present case, we have our doubts. We have to think. We have to think. We are expressing our mind. Yes, next, what else?
it thus clearly transpires that the appellant was a tenant and continued to be a tenant and was entitled to protect its possession by appropriate proceedings unless evicted in due course of law. If this is where we come from, according to us, the due course by filing a separate suit for taking possession in respect of the premises where we could be inducted, and not by way of an execution proceedings in a decree. Lordship, another argument is that we have filed an execution proceedings. Lordship, that execution proceedings was merely to give effect to the terms of settlement, because the portion that had been given to us under the consent decree, that portion was not being handed over to us. Possession was not being handed over. Once possession of that was handed over, should have recorded satisfaction of the decree because nothing else remained. Lordship, the suit, the original.
But you said the decree is a nullity. That is what you have pleaded in several paragraphs of your AO. Anyway, you make your argument. Yes, sorry, we shouldn't be interrupted.
We are grateful that your Lordship is pressing your Lordships. Lordship, there is another judgment which
Yes.
we had denied on. Lordship, this is a Bombay High Court judgment. This is also there. Start that with fine. 33. But if it is on an identical point,
Yes.
on a similar point, the only difference was in this Bombay case, the decree had been passed, and during the pendency of execution proceedings, the settlement was made. So the court held that since it was an execution of a decree which already evicted, therefore you cannot take benefit of this settlement and say that there is a new tenancy. But what happens is it holds that it is in aid of execution, and the period granted was in aid of execution of the decree, and as such dismisses the application of the tenant. Your Lordship, the relevant paragraphs are 26, 39, 43, and 44. I will just place before that the
26?
paragraphs 26, 39, 43, and 44. Lordship, I believe this is also reported in 2001 SCC Online, Bombay 930. You will find that there is an extracts of the compromise, which is at page 36. You can find the extracts at page 36, paragraph 5. As your Lordship got it.
Yes.
Preamble reads as under The suit coming on this year in the 15th year for final disposal of such and such in the presence of such and such, the advocate of the plaintiff should have pursue the exhibits. It is declared as follows: terms and conditions of compromise. The rent of the suit premises is fixed at ₹100 per month, and the said rent be deemed as standard rent. The plaintiff to give to the defendant the suit premises in rent for a period of 15 years, and the rent agreement in respect thereof be executed by the plaintiff in favor of the defendants in the said rent agreement. The plaintiff shall give in writing the permission is that the defendants, for the purpose of hotel and residence, may carry out pakka or kacha construction. The supervisor may construct well and abusive, so require the defendant to pay to the plaintiff within
Yes, Mr. Kaur.
the defendant to pay to the plaintiff within 8 days from today a sum of ₹1,000 being the amount of cost of the suit, and also to make good the damage caused to the structure and things together with other articles which were kept therein. If the defendant fails to pay the said damages, then the plaintiff shall have right to recover the said amount by initiating darkhast execution proceedings. The defendant shall vacate the premises taken on rent after 15 years, that is on such, and shall give vacant possession thereof to the plaintiff. Lordship, there is a dissection of the compromise. I'm not troubling your Lordship with it. Lordship will only find paragraph 8, compromise acted upon in pursuance of the aforesaid compromise. The original plaintiff, decree holder, present petitioner, paid ₹1,000 and in terms
Executed registered lease
on 17th January 1970 in favor of the respondent for a period of 15 years. Then there was initiation of execution proceedings. The original petitioner decree holder, soon after the expiry of lease period of 15 years, called upon the respondents to hand over vacant and peaceful possession of the suit premises. Respondent failed to deliver possession. Consequently, the petitioner initiated execution proceedings. The respondent, on being noticed, appeared and objected to the execution of the decree, contending that with the execution of registered lease deed for 15 years, a fresh contract of tenancy was created in favor of the respondent. The respondent thus contended that the petitioner did not have any right to act upon the said decree, as it stood satisfied with the execution of registered lease deed in his favor. He therefore prayed for dismissal of the execution proceedings with cause. Lordship will take, then comes the rival contentions in the next page, paragraph 14. The learned counsel for the petitioner further went on to submit that the lease agreement was executed to implement the terms of the compromise decree. Lordship, this is important. The lease agreement was executed to implement the terms of the compromise decree. Had it not been executed, the judgment debtor on the face of compromise decree would have got it executed through the court by putting decree in execution. Instead of driving the judgment debtor to file execution proceedings, the decree holder thought it fit to execute lease deed in terms of compromise decree. Thus, in his submission, by no stretch of inquiry, it could be said to be a fresh contract of lease. It was executed as one of the terms of compromise decree. He urged that decree can only be said to be satisfied with delivery of possession of the suit premises. Lordship will thereafter come straight away to paragraph 26. The Lordship will find that at page 43. Lordship, these are the issues. The substantive issues on the rival contentions between the parties are as follows: whether decree in execution is a nullity, whether the consent decree resulted in a fresh contract of lease between the parties for a period of 15 years, If yes, whether with the execution of registered lease deed, the decree in question stood extinguished and lost its executability. Lordship, as far as whether decree is in execution is a nullity, the answer has been given in paragraph 38. Your Lordship will find paragraph 38. At page 48, my Lordship.
Oh. Yes.
Second judgment.
Which is 38, not a nullity, then come to 39. Second issue.
The learned counsel for the petitioner contended that there was no intention whatsoever to create fresh or new lease. In terms of compromise, plaintiff had merely agreed that for next 15 years, the defendant would be allowed to remain in possession of the tenanted premises on the standard rate fixed in the sum of ₹100 per month. He submitted that in view of the fact that the defendant had demolished the earlier structure. That you are not troubled for 30 and 40. Kindly come to paragraph 41. It is thus well settled that whether a consent decree creates a new tenancy or continues the old tenancy has to be decided on the language of the consent decree itself. In this behalf, it will be profitable to refer to the observations of the Supreme Court made in the case of Shumati Kallu versus Zankari AIR 82 Supreme Court 813, wherein the observations were made as under. When a compromise petition is filed in an execution proceedings, kindly mark it, Lordship. This is a compromise, not in an execution proceedings. The decree is passed on the basis of this compromise. But where it's filed in an execution proceedings and a contention is raised by the judgment debtor on a subsequent execution being started by the decree holder, that the compromise has given rise to a fresh contract between the parties and that the decree sought to be executed is not executable. What is to be seen is whether the decree has been extinguished as a result of the compromise and a fresh contract has emerged. When a compromise takes place in the course of execution of a decree for eviction, Lordship, this is over there, the compromise was in execution. The compromise may extinguish the decree and create a fresh lease, or the compromise may provide a mere mode for the discharge of the decree. What actually takes place depends on the intention of the parties to the compromise, and the intention has to be gathered from the terms of the compromise and surrounding circumstances, including the order recorded by the court on the basis of the compromise. Paragraph 43 thereafter, my lord. The language in the consent decree contains ample intrinsic evidence to indicate intention to create new tenancy. As such, in my opinion, parties did not contemplate ejectment by execution of the compromise. Had the intention been to allow the judgment debtor only permissive possession for a period of 15 years and the ejectment thereafter in execution of the compromise decree, the parties would have said so. Lordship will kindly take paragraph 44 because this is where one more piece of interest is available in the decree itself, that is for recovery of amount of damages and cost of suit determined in the suit or only. The decree provides that in the event of default in payment, the decree holder can recover this part of the decree by initiating executing proceedings, but no such right has been provided in the compromise decree in favor of the decree holder. Had the intention been to recover possession by putting the decree in execution, then the decree would have so provided. It does not do so. The difference in the mode provided in two different clauses is understandable because a tenant who may otherwise be liable to ejectment may be protected by provisions of the rent tax.
Yes.
Lordship, coming back to the question which your Lordship had posted, that there was a tenancy agreement in both these cases, one being an unregistered, one being a registered. Lordship, if I just come back once more to the Supreme Court judgment 1980 Bishobani, your Lordship will kindly take paragraph 11. Even if it is assumed that the appellant was, even if it is assumed that the appellant was put in possession for the first time under a lease which turns out to be void, the appellant came into possession of the premises with the consent of the landlords and paid rent from month to month. As the lease was to be for a period of 5 years for want of registration, no operative lease came into existence. Lordship, in our case, yes, we do not have a registered lease. Lordship, the terms as provided in the terms of settlement are the terms by which we have agreed. But it is with the consent of the landlord. We have to induct it with the consent of the landlord, paid rent, and accepted by the landlord. Now, Lordship, coming to the execution application which has been filed. Lordship, the execution application was filed merely for non-payment of rent. Your Lordship will kindly take the execution application.
Is because 10 years had not expired then.
Expired.
Now the situation is this, the scenario is different.
Yes, my lord. But just to indicate why this application was made in the first place.
Where is that application? Indicate the page number where it is.
Execution application starts at page 62.
Of your written note.
So, that's the application. No
Guru ki
paperwork has been
wallah
made, so it's the stay application.
Oh, sorry, yes. Stay petition. Page 62.
Your Lordship will find the affidavit in support thereof. Starting from page 63, Your Lordship will find the two grounds that are given. Your Lordship will find that at page 67, Your Lordship will find at paragraph 8. I have sent him a letter dated 10th July 2021 requesting him to pay arrear rent by sending check in my office at 17 Princep Street, Kolkata 772. In reply to the said letter, defendant judgment by his letter issued, Lordship, paragraph 9 at page 68. Issued on 15 September 21, falsely claimed that I refused to accept rent from January 2021 and he started depositing the same before the rent controller. In the said letter, defendants also offered me to pay rent by checks. Lordship, there is no real fault. The default which they claimed on the day this application was made. Your Lordship will just take one more paragraph, paragraph 11 at page 68. It is admitted that the tenancy is covered by the West Bengal Premises Tenancy Act. Your Lordship will find paragraph 11 at page 68. In the circumstances, it is clear that the defendant has not complied with the terms and conditions as stipulated in the terms of settlement and have also not acted and complied strictly with the provisions of West Bengal Premises Tenancy Act 1997. And as such, the plaintiff is entitled to execute the said decree. Lordship, once they admit that the tenancy is covered by the Premises Tenancy Act, all proceedings have to be by virtue of the said statute. Lordship, as far as the rent is concerned, the rent has been deposited under section 21. I will just place section 21 and 22, the consequence of filing. The landlord doesn't accept, we are entitled to file under section 21. Once tendered and accepted and deposited, it is deemed to be a valid tender and there's deemed to be no default in payment of rent.
Accepted by the landlord.
Lordship, under section 21, if the landlord doesn't accept the rent, then the tenant has a right to deposit it under section 21 with the office of the rent controller. And once...
This is the 97 Act.
This is the 97 Act, my lord.
No problem. We accept your word for that.
Lordship, section 22 in support thereof says that once the deposit has been made, even 23, once it is deposited, it is not continuous to be any more default. The rent is taken as it takes care of the default. So there is no default in paying of rent.
That is it.
These are my submissions. As far as the tenancy is concerned, we are covered by the premises tenancy.
Hearing is concluded. Stop. Judgment is reserved.
My junior insists on showing one provision, but not, I don't want to, but then
What do you want to show?
he is insisting on showing 2G, which is very clear, my lord, that as to who, my lord, can
2G of what?
of the Premises Tenancy Act.
2G. We'll see.
G and
2G.
3.
Okay, G, we'll see 2G.
2G and my lord, Vishwabani covers, my lord, 3 koto?
G covers Vishwabani because 2G is
No, I'm not on.
tenant where a decree has been passed.
It may be irrelevant. Now it is 5G.
And my lord, Vishwabani only covers, my lord, PC of the Premises Tenancy Act. My lord, why they are exempted? Because it's not a registered deed.
Chalo.
Grateful, my
Huh?
Grateful.
Number 17.
I appear on behalf of the respondent. So we've received a notice pursuant to your lordship's last order. So the respondent has not been appearing in the appeal or in the last few dates before the learned trial court as well. So this is a changed brief. I was humbly requesting if my learned friends could supply us the cost papers.
Who?
On the last occasion, Mr. Rupa Ghosh and Mr. Ratul.
Today there is nobody. Pass it over. If in the case.
This matter,
Yes.
my Lord Justice Banerjee heard this with Justice Chattopadhyay.
Please.
It was heard for considerable number of days, and then I started making my submission. I have not finished. And
Mr.
so
Bose,
whatever you want.
No, you please start afresh.
Your Lordship, I'm for the appellant. I'm led by Mr. Shobhashati
You
Chaudhary.
have to wait for some days.
Yes.
Your Lordship,
So
anytime next week, Your Lordship.
yes. Let it be listed on 6th February. 6th August.
No, my Lord, after 10th August.
Acha.
Oh, no. August. Yes.
Sure,
Sorry.
Baba.
Sorry, I thought
When are you going? September?
9th from 29th to 10th. I would.
29th of August you are going.
Yes, lot of time.
I-
It will finish.
On the request made on behalf of the appellant, let this matter stand adjourned and be listed again on August 6,
Grateful, Your Lordship.
retaining its position. Pass over.
I appear to the appellant.
Yes.
My lord, this is a very small matter. My lords may not be disturbed.
Respondent is here.
Respondent has not been appearing for a very long time. This, my lords, it may come back to your lordship's mind. There was a time when a lot of litigation was going on between Turner Morrison Limited and
Mr. Hoon.
Singh Hoon.
Yes.
And after Mr. Hoon, there was a gentleman by the name of Khosla who appeared. I'm very grateful, my lord, that your lordship remembers. Thereafter, my lord, nothing has happened.
Have you?
But, my lord, the scope of this appeal.
Yes.
My lord, the scope of this appeal is very small. There was an application made by Hungerford Investment Limited against Turner Morrison. My lord, against Turner Morrison. It was a 397-399 application on the grounds of mismanagement and oppression. That application was dismissed. Hungerford preferred an appeal. The appeal was dismissed. They preferred a review application. The review application was dismissed. Thereafter, my lord, nothing happened. In the meantime, my lord, what happened was long thereafter, Ms. Hungerford took out an application under Section 340
CRPC.
CRPC, saying we had made wrong statements in the 397, 398 application, which should be disposed of. Now, at that stage, we said that you cannot go into matters which are already disposed of and which have attained elements of finality. Well, the gentleman who was appearing for Hungerford Investment Limited, the same person whom I talked about, well, it insisted that we should not be given a hearing. The learned single judge, my lord, has passed an order saying that no, I do not accede to your prayer. They will be given a hearing. But what has not been clarified by the learned judge here is another order which the learned judge has been pleased to pass. Well, since he was making application after application, application after application in a way to reopen the 397 matter, we had taken out an application being GA number 277 of 2015 saying that all future applications regarding Hungerford Turner Morrison Limited should not be heard. Should not be heard in view of the fact that the matter stands disposed of. That application was kept pending. And, my lord, it was observed, it was ordered by the learned judge that this application...
Yes.
And it was observed by the learned single judge that no other application will be heard before my application is disposed of. That is GA 277 of 2015. I have that order with me. I shall immediately hand it up to my lord. It is part of the stay application also, but since the stay application is this high, we didn't want to disturb your lordship's sense of balance. My lord, the only order which I'm praying for here is, let not this application, which is 139 now. 139 of 2013 be heard.
When did you serve notice of this appeal?
It has been served, everything has been.
Affidavit of service আছে এখানে?
My lord will check. It must be.
Which is the impugned order? দেখি মেমোটা দেখি।
Yes, my lord will find it in the memo. It's dated 18th April 2017. Has my lord found it?
That order was passed on the 340 application.
Yes. Now we say let this application moved by him, that is CA 134 of 2016, be not heard before my application is heard, which the same single judge, learned single judge, my lord, had been pleased to observe. That's the only thing which I'm praying for in the appeal. A very innocuous order. My lord will first see the 18th April order. It is passed in CA 134 of 2016. My lord will kindly remember that.
For terminals. Mr. Bose, there's a technical problem. This bench may not be able to take this up. My lord had appeared.
For Hungerford?
No, Turner Morrison.
Turner Morrison.
Hey. We are not inclined to take up this matter on the personal ground of one of us. Chaiben Namdebe brackete. Stop. This matter stands released from our list. Paragraph, let this matter be placed before the Honorable, the Chief Justice for appropriate direction.
Unfortunate, my lord. We thought it would be a difficulty with this matter is finding a bench. Because there's been so much of litigation between the parties. It seems everybody has had something to do with the matter now and then. Grateful.
बोलो तो एक्शन 20 and 21.
20 and 21 both together.
20 and 21 both. Yes.
Shuman, that senior advocate is leading me. He's out of station. She made stand over till Monday.
That is 2021 appeal. It is has appeared 3-4 occasions was called on by your lordship. I am the plaintiff. Now because it is-
Plaintiff respondent.
Yes, in the respondent, yes, plaintiff respondent. I cannot proceed with my suit and for last 4-5 years. Because he's not in Calcutta, I have not done that. But on the next day, I understand what.
Why are you telling her? She has no control. You better over a cup of tea, Mr. Ganguly. And tell Mr. Ganguly.
কোথায় গেল দেখ খুঁজছি is in the second row.
Accommodation is paid for on behalf of the appellant. Appellants করবে. Paragraph. Mr. Mitro, learned advocate appearing for the respondent oblique plaintiff, says that the plaintiff cannot proceed with its suit in view of pendency of this matter, with his suit. It's paragraph. Let this matter be listed once again on next Monday.
Yes.
Monday.
Monday, these are non-commercial matters.
Let it be in the list. Then it will be taken up perhaps on Wednesday.
Perhaps on Wednesday.
Retaining its position. Same order in both 22 and 23.
No, time.
Yes, 5 p.m. marked 5 p.m.
Mr. Mitra will.
You wanted the time.
You can come on Saturday.
Really seriously, huh?
I'm opposing Saturday.
Hey, opposing
Saturday.
Court khula.
I'm aware, but not this matter.
Pulling
Not this matter.
Raja, এটা what is going on? Coming on Saturday. Double fee পাচ্ছি এটাতে।
PNBর সামনে জল জমে গেছে।
PNBতে জল জমে আসছে। কারণ ভাও করে দাও। হয়ে গেছে। অনেকবার এক প্যাটার হয়েছে। Item number 24. I'm for the appeal.
I'm for it. But in this matter, my lord, I was arguing before the other way. Now, my lord, perhaps the matter has to be heard again.
Afresh. Yes. Start.
So before I start, my lord, only to give a cursory glance of the earlier submission, my lord, your lordship was pleased to
Roughly how long you will take, Mr. Chakraborty?
take this side of the house.
This side of recess. Oh, you have only 15 minutes.
Then we'll be only recapitulate the other the thing.
Anyway, you start.
But if your lordship kindly once takes the order dated 13th June 2025, because in that order your lordship has in a nutshell framed what argument I have made on that day.
Oh, acha, dekhi.
একটু অর্ডার শিটটা দিন। June 13 জুন।
থাকবো না আগরতলায়।
সাহেব দুটো জাজমেন্ট দেখে আসতে বলেছে সেটা কোথায় লেখা আছে
On June 11, 2025, Mr. Chakraborty, Learned Counsel representing the appellant, began his argument. He had watch us.
Yes.
Should I read the order or you also?
No, we read the order.
Yes, Lord. So, the first limb of argument was that, my lord, so far as the pendentality interest which was awarded, that was beyond the contract, and the learned arbitrator had, my lord, considered some decisions which were passed under the 1940s Act.
Right. Agir bench. So basically, your challenge is to the interest pendentality
Well,
and also post-award, because
as well as the other, because, my lord, what happened, there were two parallel arbitrations were going on before the same learned arbitrator. And on the same date, two awards were published. In both the awards, my lord, the learned arbitrator has awarded the pendentality interest as well as post-award interest. Now, both were, my lord, assailed in different section 34 application. One was numbered as 141, another was numbered as 142. This one is 142. So 141 gone before the Honorable Justice Mousumi Bhattacharya, my lord. And there, my lord, the entire interest part, my lord, was, my lord, set aside because of no reason, as well as the stipulated prohibition in the contract which says that no interest would be payable. Basically, the pendentality part of the interest was set aside on the ground of beyond contract and because of the prohibition clause. And the second part, that is the post-award interest, that was set aside because of lack of reasoning.
So two section 34s went to two different judges.
Yes, my lord.
In one you succeeded.
One I succeeded. One I succeeded only on the point of interest, not on the others.
Other part it has been,
But
Not
you have not challenged that.
so far that point has not been.
That has not been
challenged.
But so far the award is concerned, that has been sustained, Lordship.
The other part was sustained. Now, my lord, today, basically, my lord, the interest part is mounting, and that is the main concern. The other portion of the award, my lord, as such, my lord, is amount is not more than nearly 30 lakhs, and the interest is more than almost it is reaching to 2 crores. Right?
One is pertaining to railway, another is pertaining to airport. There are two contracts. And that on that basis, the two arbitration corresponding, it has been done.
What was the nature of work you had done?
Nature of work is one is we are the subcontractor and they are the contractor directly under the government authority. And on that basis, there is a contract and we have done the work. We have to done certain extra bit of work and subsequently.
Construction work, what work?
Yes, construction.
This locomotive set.
It's pertaining to railway construction.
Another is Air India
hangar
in the airport.
216 sittings has been held. 216.
Two different arbitrators.
Same arbitrator.
Honorable Justice Manjula Bose.
If I show your lordship the portion of interest in the decision of the learned arbitrator in interest, not it is almost line by line same. It is a replica of one each other. So section 34 my lord ultimately receives my lord two different fates before two different judges. So before that, my lord, since I was arguing on the point of 31.7, I was relying on 31.7 because all the contract says that there will be no, your lordship has already quoted that prohibitory order portion. There will be no interest on pendential item. So 31.7, my lord, changes the entire scenario than what was prevailing under the 1940s Act. So I will once place, my lord, 31.7 along with 28, my lord, 23. Unless otherwise agreed by the parties, where and insofar as an arbitral award is for the payment of money, the arbitral tribunal may include in the sum for which the award is made interest at such rate as it deems reasonable on the whole or any part of the money for the whole or any part of the period between the date on which the cause of action arose and the date on which the award is made. So it, my lord, speaks of pre-reference interest as well as pendent interest, but the opening line is unless otherwise agreed by the parties. So this was missing in the 1940s Act. So with the inclusion of unless otherwise agreed by the parties, my lord, the jurisdiction of the learned arbitrator to award interest, my lord, becomes restricted by virtue of this section itself. However, the post-award part is not covered under 7A, that is in 7B. A sum directed to be paid by an arbitral tribunal shall, unless the award otherwise directs, carry interest at the rate of 2% higher than the current rate of interest prevalent on the date of award, from the date of award to the date of payment. And the expression current interest has been defined. That is not, my lord, I am reading, my lord. Therefore, unlike 7A, 7B does not start with unless otherwise agreed by. Therefore, it is a provision independent of the agreement of the parties. And this will obviously, my lord, will ultimately supersede the agreement, even if there is any prohibition clause, my lord. So I am, so far as post-award concern is concerned, I am not arguing that because of my prohibitory clause in the agreement, post-award will also be, my lord, not payable. But, my lord, on the post-award, my challenge is that since interest itself is a parasitic claim, it depends on the existence of the principal claims. And all these principal claims, my lord, your lordship may recollect, during the pendency of the section 34, whatever, there are 4 claims were also assailed in section 34, but we have paid that. Yes.
Yes.
Yes. Therefore, so far as the post-award portion is concerned, my lord, your lordship has recorded in the last day's order also, during the pendency of section 34, without prejudice to our rights and contention, we have paid 4 claims. Now, my lord, my case is that out of the balance claims which are today under challenge before your lordship, because there were 14 claims which were allowed, and out of that, just a moment, not 14 or 9, I have to confirm. Yes, 15 claims were allowed, out of which, my lord, 4 claims were paid. And all the rest claims which are today, my lord, subject matter of challenge are, according to me, my lord, beyond the contract. The contract says that the piling and the excavation will be on all types of soils. Now the arbitrator has given an award on the hard soil separately. It says that for the pile will, for the purpose of payment, only the different distance between the pile cap and the bottom of the pile will be recorded. But the arbitrator has awarded the portion of upper the pile cap from the ground level. So these are things that I will place one by one when I will deal with the claims. So all these claims which were not payable under the contract were not paid, and other 4 claims were paid. And in fact, the Milord, today, Milord, they are not aggrieved as such, because whatever the value of LOI, they have received more than that. There is no dispute on that. Therefore, while dealing with Milord post-award interest, Milord, I will be placing those claims separately to show that are dependent on the parasitic, dependent on the principal claims which are not payable, and lack of reasoning. So, Milord, last day I have placed in detail, Milord. I think I should, Milord, just only one case law that I had placed that day. I have placed many case law, but one was the sheet anchor of my argument, that is Shotten. Yes, Milord. That was, Milord, 2019-17 SCC 780.
Joy Prakash
Associates. Milord, for Milord Justice, I will just indicate the relevant portions. The other judgments I have only given the paragraphs only to avoid the repetition, Milord. But I am reading from para 2. The dispute which has travelled to this court pertains only to the question as to whether the arbitrators could award any interest in view of clause 50 and 51 of the general conditions of contract, which govern the terms between the parties. The objections were filed before the High Court. A single judge of the High Court of Delhi passed the order dated 15/11/2011, quashing the award limited to the interest that was awarded by the arbitrators. The appellant preferred intra-court appeal, which has been dismissed by the division bench of the High Court.
Chakravarti,
Yes,
just we'll interrupt you for a moment. Mr. Chatterjee, your matter is likely to go on till recess, or have you settled?
We have not settled, but I must tell you, Lordships, what has happened. The settlement talks were held on 2 occasions. Nothing very encouraging or concrete has emerged. But there's, I think, still a request from the other side that we should endeavor for a settlement.
Have you tried official mediation?
That has not been done. That has not been done.
Would you, no, sitting between the two of you, you see, why is mediation becoming so popular? A lot of disputes we see, because these are trained mediators. They are facilitators, as you know.
In fact, Millard, we have given all our proposals. The company, my friend's client, is based in France. Every time they come and say that we have to get back to our parent company and come back. And this will be a never-ending process. So it cannot go on. The next day, I shall be compelled to request your lordship to take up the matter, unless it goes for a formal mediation.
Right. Next day also, please inform us whether both parties are agreeable for a formal mediation. We strongly suggest that.
Yes. Either it goes for a mediation, or Miller, kindly allow me to proceed.
Then you will press your appeal. So should we keep it next week or 2 weeks? Tell us.
13th of August is a Wednesday. That will give almost 2 weeks to the other side.
Come back on 13th then.
At the same time.
12:45 matter. Order record koro. Auto number item bole dao ke? 25.
25.
Learned advocates for the parties tell us that talks of settlement are still in progress. Stop. Paragraph. We request learned advocates for the parties to obtain instruction from their respective clients as to whether or not the parties are agreeable to try out mediation to resolve the disputes between them. Paragraph lists this matter once again on August 13, marked 12:45 p.m. Mark 12:45 p.m.
Keep level. Millard, the mediation is perhaps the best option. Otherwise, Millard, I'll have to press.
Yes. Yes, Mr. Chakraborty.
Only one problem. We are based in France. Mediation by authorized representative or by video conferencing.
Authorized representative is fine.
We are based
That's yes. We strongly recommend it. It's yielding very good result, Mr. Ghosh.
These matters perhaps. It's a do or die situation interim. Do or die, you get the order on the first day or on the returnable date or not. The suit ends there.
All right. Yes.
Yes, Millard. So the sixth line from top of Millard paragraph 2. The appellant preferred intracourt appeal, which has been dismissed by the division bench of the High Court, thereby upholding the judgment of the single judge. The effect is that the High Court has held that no interest is payable as clause 50 and 51 of GCC bar the arbitrators from granting interest. Thereafter, Millard, clause number 50 and 51 are quoted, Millard. It may be pointed out that the interpreting clause 50 and 51 of the general conditions of contract, the view taken by the High Court is that these clause categorically provide that no interest to be payable, such and such. Those clauses are quoted, Millard. Thereafter, your lordship can see in paragraph 5, notwithstanding the same, the learned arbitrator granted the interest by relying upon the law declared by this court in Port of Calcutta versus Engineers Day Space Age and following observations from this. So, Millard, in our case, Millard, coincidentally, this same case law has been referred. This Calcutta Port of Calcutta.
Same?
This same case law has been relied on by the learned arbitrator, which was done in that case by the arbitrator, and later on Millard set aside by High Court and confirmed by the Supreme Court. That's setting aside. Then Millard, paragraph 10. Mr. Gaurav Banerjee, learned senior counsel, appearing for the respondent, gave equally emphatic reply to the aforesaid submissions of Mr. Suri. His first argument was that clauses in Harish Chandra's case and the present case were altogether different. From here, it is important. Insofar as the instant case is concerned, it was governed by the law laid down by Jayaprakash Associates Judgement, which was in fact a case between the same parties, and in the case of the court held that while construing the identically worded clauses, came to the conclusion that the arbitrators were precluded from granting any interest. His another contention was that there was a difference between the scheme provided under the Arbitration Act 1940 when contrasted with 1996 Act. He argued that most of the judgments cited by the appellant, including Harish Chandra, were under the 1940 Act, whereas in the instant case, award was passed under the 1996 Act. Lord, in this particular matter, Millard, almost all the incidents have taken place regarding change of law during the course of arbitration. The reference was when the dispute arose, that was under the 1940s Act. The clause was under the 1940s Act, but the reference was made under the 1996 Act. And when, Millard, ultimately the award was passed, Millard, that was prior to the amendment of 2015. Now, para 11. In the first instance, the learned senior counsel pointing out that even the arbitrators accepted on the interpretation of GCC clause 50 and 51 that these clauses deny interest on the appellant's dues by the respondent due to dispute, etc. Notwithstanding the same, the majority opinion awarded the interest relying upon the judgment of this court in Port of Calcutta. The learned single judge of the High Court, while reversing the aforesaid view, pointed out that 1996 Act had altered the position contained in 1940 Act. Under the new Act, an arbitrator could not award pendentality interest when there was an express bar against award of such interest. This legal position is contained in section 31(7)(a) of the 1996 Act, and the legal position stood crystallized in Syed Ahmed versus State of UP. Therefore, held the learned single judge, when clause 50 and 51 of GCC imposed a complete bar on arbitral tribunal to award pendentality interest, the arbitrator has no jurisdiction to award interest. Mr. Banerjee submitted that. The learned single judge even noticed the judgment of Harish Chandra and distinguished the same on such and such. Next, my lord, paragraph 13. Insofar as the power of arbitral tribunal in granting preference and or pendentality interest is concerned, the principle which can be deduced from the various judgments are summed up below. But the 13-1, Calcutta bench judgment of irrigation such and such, exhaustively dealt with by this very issue, namely power of the tribunal to grant preference and pendentality interest. My lord, this also was the Constitution bench, of course, construed the provision of 1940 Act, which act was in vogue at that point of time. So this judgment is against me, my lord, but that was under 1940 Act. This is the judgment of Constitution bench. And in course of the last time hearing, my lord, your lordship has given 2 judgments also and asked me to come back with those 2. I have also come back with that. Those are also, my lord, under 1940 Acts, which invoked at the time. At the same time, the Constitution bench also considered the principles of grant of interest, applying the common law principles. It held that under the general law, the arbitrator is empowered to award interest for the pre-reference, pendentality, or post-award interest. This proposition was called out with the following reasons. The question still remains whether arbitrator has the power to award interest pendentality, and if so, on what principle. We must reiterate that we are dealing with the situation where the agreement does not provide for grant of such interest, nor does it prohibit such grant. Therefore, this case, my lord, there was neither any prohibition clause nor any enabling provision. So on that factual gamut, my lord, this constitutional bench decides the issue. The other words, we are dealing with a case where the agreement is silent as to award of interest. On the conspectus of aforementioned decisions, the following principle emerges. A person deprived of the use of money to which he is legitimately entitled has the right to be compensated for the deprivation, call it by any name such and such. And number 2, an arbitrator is an alternative forum for resolution of dispute arising out of the parties. If so, he must have the power to decide all the disputes and differences arising between the parties. If the arbitrator has no power to award interest pendentality, the party claiming it would have to approach the court for that purpose, even though he may have obtained satisfaction in respect of the claims from the arbitrator. And number 3, the arbitrator is the creator of an agreement. It is open to the parties to confer upon him such powers and prescribe such procedures as followed. Lord, all this, Lord, thereafter, Lord, under 1940 Act, therefore, I am not, Lord, reading the entirety. Next, Lord, 13.4, which, Lord, clarifies the position. Now, 13.4. Insofar as 1940 Act is concerned, it was silent about the jurisdiction of the arbitrator in awarding pendentality interest. However, there is a significant departure on this aspect insofar as the 1996 Act is concerned. This distinction has been spelled out in Syed Ahmed case in the following manner. Re-interest from the date of cause of action to the date of award. The issue regarding interest as noticed above revolves around clause G 1.09 of the technical provisions forming part of the contract extracted below, then it is extracted below. In 14, the decision of the court which reference to the awards under the old Arbitration Act, making a distinction between the pre-reference period and the pendentality period, and the observations therein, that the arbitrator has the discretion to award interest during pendentality period, in spite of the bar against interest contained in that contract between the parties, are not applicable to the arbitrators governed by the Arbitration and Conciliation Act. Since I have skipped some of the portions of the constitutional bench judgment, I will give a very brief gamut of the judgment. What it says, there may be a prohibition in the agreement, simply saying that the arbitrator shall not, the party shall not be entitled to any interest. But that will not take away the right of the arbitrator to grant interest unless the contract specifically says that arbitrator shall not have the power to grant interest during the pendentility period. Because at that point of time, there was no legal provision in the Arbitration Act 1940 which takes away the power or which restricts the power of the arbitrator to grant interest. But at the same time, it is a common law principle that if a person is deprived, he should get interest. So applying that, my lord, it was held that, and interpretations have, my lord, come up in the aid of the deprived persons to say that, no, if categorically it is stated in the agreement, arbitrator shall not have power, then only it will preclude the arbitrator from awarding. But that is what is said here, that these philosophy or these particular principles which have been laid down by the constitutional bench also has undergone a change under the 1996 Act. Because now Act says subject to agreement. Everything is subject to it. Once the Act recognizes that specifically, there is no other provision for again going for an interpretation and construction of that arbitration. So what is said here is that paragraph 14, the decision of the court with reference to the award under the old Arbitration Act, making a distinction between the pre-reference period and pendentility period and the observations therein that the arbitrator has the discretion to award interest during pendentility period in spite of the bar against interest contained in the contract between the parties are not applicable to arbitrations governed by the Arbitration and Conciliation Act. I'll beseech your lordship kindly to mark this portion. Next, Lord, the aforesaid position is reiterated. Lord, the judgment which I am citing, Lord, that is, Lord, three judges bench judgment. And before that, Lord, Kamachi was delivered. Paragraph 14. The aforesaid position is reiterated in Sri Kamachi Amman Construction versus Railway and Union of India versus Bright Power Projects India Private Limited. Later judgments is by a bench of 3 judges. This legal position is reiterated in Chittaranjan Maiti versus Union of India, which is authored by one of us. In that case, the court considered the very same question which falls for determination by us, namely, whether the arbitral tribunal was justified in awarding interest on delayed payment in favor of the appellant. After noticing that clause 16.2 of GCC, in that case, bars the payment of interest. 16.2. Yes. Bars the payment of interest. It was held that under the 1996 Act, the position wherein is different from the 1940 Act, the interest could not be awarded. Following observations from the judgment may be noted. Relying on the decision of the court in Ambika Construction versus Union of India, Lord, that is the judgment, perhaps your lordship, it has fallen from your lordship. The learned senior counsel for the appellant submits that mere bar to award interest on the amounts payable under the contract would not be sufficient to deny payment on pendentility interest. Therefore, the arbitrator was justified in awarding pendentility interest. However, it is not clear from Ambika Construction as to whether it was decided under the Arbitration Act 1940 or under 1996 Act. It has relied on a judgment of the Constitution Bench in Irrigation Department versus State of Odisha. This judgment was with reference to 1940 Act. In 1940 Act, there was no provision which prohibited the arbitrator from awarding the interest for the pre-reference, pendentility or post-award period, whereas the 1996 Act contains a specific provision which says that if the agreement prohibits award of interest for the pre-award period, the arbitrator cannot award interest for the said period. Therefore, the decision in Ambika Construction cannot be made applicable to the instant case. Because Ambika Construction, I have gathered that it is also under 1940 Act. But that ultimately followed another judgment, which was GC Rai, that was also under the 1940 Act. In a recent judgment, Reliance Cellulose Products Limited versus ONGC, the entire case law on the subject is revisited and the legal position is re-emphasized. That was also a case which arose under the 1940 Act and held that under 1940 Act, an arbitrator has power to grant pre-reference such and such. Now, paragraph 16. That is also very important. After discussion and analysis almost all the judgments on this subject. The legal position is summed up in the following manner. It is not quoting Reliance Cellulose. A conspectus of the decision that have been referred to above would show that under the 1940 Act, an arbitrator has power to grant pre-reference interest under the Interest Act 1978, as well as pendentalite and future interest. Further, he is constricted only by the fact that an agreement between the parties may contain an express bar
Yes.
to the award of pre-reference and or pendentalite interest. Since interest is compensatory in nature and is parasitic upon the, I have borrowed my word parasitic from here only, beloved, and is parasitic upon a principal sum not having been paid in time, the court has frowned upon clauses that bar the payment of interest. It has therefore evolved the taste of strict construction of such clauses and has gone on to state that unless there is a clear and express bar to the payment of interest that can be awarded by an arbitrator, clauses which do not refer to claims before the arbitrator or disputes between the parties and clearly bar the payment of interest cannot stand in the way of an arbitrator awarding pre-reference pendentality interest. Thus, when the contracts clauses such as clauses in Ombika construction with the clauses of Theory Hydro Development Corporation, it becomes clear that unless a contractor agrees that no claim for interest will either be entertained or payable by other party owing to dispute, difference or misunderstanding between the parties or in respect of delay on the part of the engineer or in any other respect whatsoever, leading the court to find an express bar against the interest, a clause which merely states that no interest will be payable upon amounts payable to the contractor under the contract would not be sufficient bar for an arbitrator from awarding pendentality interest under 1940 Act. As has been held in first Ombika construction case, the grant of pendentality interest depends upon the phraseology used in the agreement clauses conferred power relating to the arbitration, the nature of claim and dispute referred to the arbitrator, and on what items the power of award interest has been taken away and for which period. We hasten to add that the position as has been explained in some of the judgments above under section 31(7) of 1996 Act is wholly different. Inasmuch as section 31(7) of 1996 Act satisfied agreements between the parties and states that the moment agreement says otherwise, no interest becomes payable right from the date of cause of action until the award is delivered. Obviously, it doesn't cover the post-award part. In this whole conspectus and keeping in mind, in particular, that present case is regulated by 1996 Act, we have to decide the issue at hand. At this stage itself, it may be mentioned that in case clauses 50 and 51 GCC put a bar on the arbitral tribunal to award interest, the arbitral tribunal did not have any jurisdiction to do so. As pointed out above, right from the stage of arbitration proceeding till the High Court case, clauses are interpreted to hold that they put such a bar on arbitral tribunal. Even the majority award of the arbitral tribunal recognizes this. Notwithstanding the same, if it awarded the interest by relying upon Port Calcutta case, the High Court, both single bench as well as division bench, rightly noted that the aforesaid judgment was under 1940 Act and legal position in this behalf have been a paradigm shift, which position is clarified in Saeed Ahmed. This rationale given the High Court is in true with the legal position which stands crystallized and catena of judgments as noted above. So, my lord, after holding this, my lord, paragraph 24, ultimately the judgment of the High Court single bench as well as division bench was, my lord, upheld. My lord, pausing here for a moment, my lord, therefore, I will show from the award itself that in our case also the learned arbitrator has relied on the Port of Kolkata case and awarded the interest. And so far as the post-award interest concerned, as such, my lord, no reasoning has been given. And whatever reasoning, when I will place, my lord, your lordship will see, those are, my lord, perhaps no reason. And that is the reason in the other arbitration it has failed. the entire interest has been, my lord, set aside. My lord, the part of award.
Your clause 16, subclause 2 of GCC, which is the clause barring payment of interest, that only says interest, not pre-award, post-award, nothing. It says
Nothing.
interest on money payable.
Money payable.
That would cover everything.
Yes, it would cover everything, but at the same time, my lord, I'll say 7B, 31(7)(b).
Right.
31(7)(b), my lord, that is not made subject.
Have you considered whether parties can contract out of a statutory provision?
My lord,
we are trying to raise this in your favor.
oh yeah, absolutely, my lord, absolutely. My lord,
Consider it.
I have covered that aspect on the thing that arbitrator cannot rewrite the contract. Cannot rewrite the contract, and there is no waiver or estoppel against the statute. But at the same time, my lord, unless the statute specifically bars the parties to make a contract to the contrary, my lord, perhaps that may not be a bar.
এই ম্যাটারটা যেন উপরের দিকেই থাকে, হিয়ারিং শুরু হয়ে গেছে তো।
Can it be on next week? Because from tomorrow, my lord, I will be out.
Next week when?
As and when, your lordship.
Monday. It will be taken up
Yes,
possibly on Wednesday. Lekho, in continuation of his argument, Mr. Chakraborty submitted that the position under the 1996 Act, insofar as the issue of payment of interest is concerned, is wholly different from that, is wholly different from what the position was under the 1940 Act. Stop. Under the new Act, if the parties agree that no interest is payable on claims allowed, or no interest is payable on money due to one of the parties, the arbitrator loses the power to award, to grant pre-award interest on the claims allowed.
Pre-award and payment related.
Pre-award doesn't cover that.
Very sorry. Pre or post.
Stop. Paragraph.
The reference first.
Insofar as the 11 claims which have still not been paid but allowed by the arbitrator, Mr. Chakraborty says that those claims are outside the scope of the contract and therefore should not have been allowed by the arbitrator. Stop. Consequently, the post-award interest on such claims are also irregular.
And I will argue the point of limitation also on those things.
Paragraph lists the matter once again on Shamnir for August 4. August 4 for Mr. Chakraborty to continue his argument. এটার আগে কিছু ঢুকিয়ে দিও না, এটা যেটা শুরু হয়েছে এটা লিখছি না ওখানে আমরা।
Most likely it will be taken up on Wednesday. It will be taken up on Monday or Wednesday.
Look, Monday first commercial. So unlikely.
And on the last day, I have given one copy of Syed Ahmed. I'll supplying the other copy.
Very well. Very well. We will keep it on Wednesday itself. কি হচ্ছে? নোটটা
compilation করে দিব।
তাড়াতাড়ি কি
I said.
But I have told Mr. Nairi that I will take 40 seconds of his 15 minutes.
Okay, sure.
But only to bring this to your lordship's notice that we have argued only on the law. So far as the legal, the factual disputes are concerned, Lord, they're all put in the note. We have not troubled your lordship.
All right.
What we have done in the note is to place their submission, our submission, how it has been dealt with in the award, and how it has been dealt by the learned honorable judge on each of the issues.
All
Look, there is one other thing with regard to the point that they took with regard to service tax, which was not taken in the earlier pleadings and not canvassed.
I want to withdraw that.
Notification, something was produced.
I want to withdraw that.
Withdraw that.
I want to withdraw. After the notification that was supplied, that leads to only that notification, it came into the act. But thereafter, almost on the same day the notification came, it only applied to containers and not for rakes. So I have to withdraw that note, sir.
Very good.
But in our note, Lord, we have indicated that on the various factual aspects that my learned friend has argued before your lordship, they were not there earlier on. Lord, there are two judgments which we had missed out, one of the Supreme Court, one of the Delhi Division Bench. Lord, if your lordship permits me to, Lord, give your lordships a copy.
Give.
I'm handing over a copy to my learned friend also. On the point that if it has not been taken before the arbitral tribunal, the party is precluded from taking it in the section 34 or section 37 stages. But insofar as the Supreme Court judgment is concerned, 2018, volume 2, SEC 182, paragraphs 21 to 27. Paragraphs 21 to 27. And the Delhi Division Bench, paragraphs 19 to 21. And in fact, they go as much as to say if you've taken the point but not canvassed it, even then you are precluded.
Paragraphs?
The Delhi one, paragraphs 19 to 21. The Delhi Division Bench. And the Supreme Court, is paragraph 21 to 27.
I'm going to copy down.
There's a factual point not argued, not taken before the tribunal, can't be taken for the first time in section 34.
Of course, not in 37. And in fact, the Supreme Court goes so far as to say that if you have taken the point and not canvassed it, even then you are precluded.
Very well.
So these are my submissions.
Give me 1 minute just to go through this sentence once.
On the last occasion when I finished, I did not refer to the judgments, and my lord had said, just file a summary of judgments. But I'm filing the summary of judgments referred to by me, my lord. These are judgments referred to me in the notes, and there's a summary of judgments, my lord. But the first point that was urged before this honorable court was on applicability of section 37 to the scheme of act, and what are the powers of the section 37 court in dealing with an award, and the order of section 34 when the award was not set aside by the 34 court. Well, my respectful submission is that section 37 of the act gives a dual power to the appellate court. The dual power is, my lord, that the first thing that the section 37 court will look into, because section 37 does not say anything about how to go about the appeal. And my lord, it is unlike the civil law, where there is first appeal, second appeal is only on points of law. This is a statutory appeal under the act, which just said that the court will hear appeals on setting aside or refusal to setting aside arbitral award. So, my lord, it has been categorically held by the Honorable Supreme Court that all trappings of section 34 would be applicable to section 37 court while dealing with, my lord, the award and also the order of section 34. So the 37 court, my lord, has the power first to look into the judgment of the section 34 court and how it has applied the provisions of section 34 qua the award, and then also look into the award in the light of section 34, that the award can be or cannot be set aside under section 34. So the section 34 court has a dual responsibility of looking into the setting aside order or non-setting aside order and also the award, because my lord, otherwise, and section 34 is not an appeal. Section 34 is a challenge of the award only on the ground that set out in section 34. So it is not a regular first appeal where all points of facts, laws and everything is dealt with. So the contours of the challenge must be within the ambit of section 34. So the section 37 court would definitely test the order of the section 34 court and also look into the award. So the 37 court does not stop at, my lord, the legality and validity of the section 34 judgment. It has to, my lord, go into the contours how the section 34 court has gone into the award and the challenge thereto under the provisions of section 34. So, my lord, the ambit of section 37 is wider than a civil appeal of a second appeal, but restricted to the trappings of section 34. So, my lord, therefore, while deciding a section 37, if it is found out that the section 34 court had missed out on points which are the grounds of challenge of the award, the section 34 would definitely have to insert its own opinion as to the legality and validity of the award with the provisions of section 34. And therefore, the section 37 court must look into the award. And, my lord, has to go into the award and how it can be challenged under the contours of section 34. And that has been all the Supreme Court judgments, including, my lord, Punjab Civil Supplies, which was referred to my learned senior friend, has not gone up to saying that, but it has always said that trappings of section 34 would be always there with the section 37 court. Well, I go one step further by saying that section 34 court has a dual responsibility. Checking the 34 order, setting aside or not setting aside, and also checking the award in light of the grounds under section 34. I'm not coming to this, the instant case. But the instant case, the challenge is on perversity. And my lord, all the judgments which have come up after, my lord, the amendment to the 96 Act, because, my lord, the challenge is now very short. The points are very short where we can attack, because it has been held that arbitrators are the masters of all evidence. Arbitrator can look into any law, look into the agreement, interpret the agreement according to it, and the court will not go into how they have interpreted the agreement. So the challenge is very narrow, but within that narrow challenge, my lord, the one thing which comes up is where vital evidences have not been looked into by the tribunal, then that is perverse. This was the main reason why, my lord, the curative petition in Delhi Metro was allowed. Delhi Metro, my lord, initially had upheld the award, but when it came to the curative petition, it was allowed only on the ground that a vital piece of evidence was not looked into by the tribunal, and it has set aside the award, my lord. But in this case, my lord, will kindly see from the award that all the points that I were urged, that letters, they do not find any place in the award. That the award, my lord, I have said, is on three heads. First is on rakes, second is on loss of rebate, and loss of profit. But on loss of rakes, I have said that the tribunal had gone into an external interpretation of the agreement which was not contemplated on the agreement, based on an expert evidence who is not an expert at all. But he has gone on to, but when it's shown that there is an agreement and a formula is mentioned in the agreement, though not for, but it is mutually agreed price. A mutually agreed price, when the parties do not mutually agree, then, my lord, income tax depreciation has to be taken into consideration. And not some, my lord, inter-railway transfer of assets where it is transfer between railways and it's a book transfer. So normally a court or a tribunal will look into depreciation under the income tax rules. And though it was said before the tribunal, though the documents were placed before the tribunal and also before the section 34 court, the court still believed on that, my lord, inter-railway transfer of assets, which is not applicable in this case, my lord. The second point was, my lord, on the loss of freight rebate, my lord, and I have tried to portray before this honorable court that there was no freight at all, except those 9 months. It is from the correspondence, it is clear that there was no freight. If there is no freight, then there is no freight rebate. And, my lord, contrary to that, if they claim freight rebate, I can claim, my lord, freight. Because first the freight will come and then the freight rebate will come. So my counter claim was on freight. The freight I lost. Arguments were made that, my lord, the wagons are put in the pool. Wagons were put in the pool, so I earned from the wagons. I will definitely earn from the wagons, but I have lost out on freight which I would have got from you. That was my extra earning out of this agreement. But the fact remains, my lord, that...
So your wagons were lying idle?
No.
They were employed otherwise, engaged otherwise?
Yes.
Good.
No, my wagons are in the pool. They have been used by people. But the freight that they would have put in,
For what? Your wagons were not idle.
No, they were not idle.
They were earning freight.
They were earning freight, but
On the other hand, they had to hire other wagons and they lost out on 10% of the.
no, they didn't wear. Well, they didn't have to wear other wagons, my lord. They did not have goods for my lord the WIS. My lord, the evidence that they had given for about 600 my lord railway receipts, they are my lord of different schemes, of different loading points. And my lord, I have placed that there was no iron ore at the Borai Jamda.
The post 2015 award.
Yes. And my lord, there was no goods on Borai Jamda to load under WIS. And my lord, the third point on loss of profit, my lord, I have said they have relied upon two agreements which has no connection with the agreement. And my lord, another thing which I have emanated from the judgments is the award must shock the conscience of the court. The award may be so perverse that shocks the conscience of the court. But it has shocked my conscience, my lord, that the award has shocked my conscience. No. And I submit that, my lord, I have tried to portray in a manner that it must shock the conscience of the court that an award is so perverse, so beyond documents, to pass such an award, and that too, my lord, public money. Public money is my lord completely perverse to the my lord to the context of the case. When my lord glaring evidences are there before the tribunal, which was completely overlooked, which is my lord Associated Builders, Sangyong, and my lord up to up to Delhi Metro, and my lord, this is the only way where an award can be challenged in a way that evidences are not looked into. So my lord, these are my submissions, my lord. I would like to end, my lord, by quoting Robert Frost.
Yes.
Road not taken. The last three lines. Two roads diverged in a wood, and I took the road once less traveled by, and that has made all the difference.
Wonderful. Have you included that in your note?
No, madam. Well, I would like to quote my process then.
But he's withdrawing one of the arguments which was made because the note has been filed.
No, we've noted that. That Sesagua, there was no service tax.
Service tax, I'm withdrawing.
That's withdrawn.
I'm withdrawing.
We have noted that. Judgment লিখতেই যথেষ্ট।
Okay, brief me again.
একটা আছে, ঠিক আছে, এসো। One of the points that was argued by Mr. Lahiri, learned advocate for the appellant, on the last occasion, was that the invoices of Sesa Goa that were relied upon by the respondent were obviously procured and manufactured as the same did not reflect service tax. Paragraph today, Mr. Lahiri has withdrawn that argument in court. In view of the notification that was produced on behalf of the respondent showing exemption of what? Exemption of service tax.
No, it's not exemption. It was only on containers and not on rakes.
Service, it was not payable.
On this service, it was not payable.
Showing exemption, showing that service tax was not payable on the kind of service that Seshagua
obtained
from the
respondent.
But the woods are still dark and deep, and many more miles to go before either of us can sleep.
Paragraph. Hearing is concluded. Judgment is reserved. দু সাইডে দিক ওদিক পাঠিয়ে দেবে তারপরে
Non-commercial matter, item number 23.
Lord, this is my opinion, Lord. From 34. Other side, my Lord, is Mr. Shaha. Mr. Priyankar Shaha. Junior is his junior is
Can it be made not today but just today, Your Lordship?
Mr. Shaha raised a very serious grievance
Yes,
on the last occasion.
Personal reason he could not be here.
And my Lord, I'll tell your Lordship. Now, this is your fallen from your Lordship. There was another matter. Proshenjit Chatterjee, my Lord, I started where some papers were not there. Your Lordship was sitting with my Lord Justice Rai Chattopadhyay. Your Lordship had kept it 2 days later when my Lord this bench was there. I told Mr. Shaha over there was a matter which was going on that in case it's taken up, I'll come back. And my Lord, I saw the video when the matter was taken up. Ultimately, he didn't even bother to mention the court that Ms. Banerjee was here. She requested me, she told me. And the matter was dismissed by your Lordship, saying that, I know how to put them to task. Obviously not at me, but this, my Lord, is not something, my Lord, which we are expecting.
On the prayer made on behalf of the respondent, let this matter stand adjourned for the day.
Grateful. I'm coming up with a restoration for that.
It will be allowed, you know that.
He should have mentioned, my Lord, we are now 18, 19 years.
You admonish him outside the courtroom.
Item number 27.
IAPA for the respondent number 1.
Who is the appellant? Mr. Tilak Bose? No?
Mr. Tilak Bose, my Lord, is now the present appellant. But, my Lord, the appeal itself has, my Lord, lost its purpose. And, my Lord, the prayers that are now made in this application, they go beyond the purview of, my Lord, the original suit itself. So, I am wondering what he is really asking for. Besides, my Lord, all
somebody is running towards the... Oh. She's assisting you?
Yes.
Oh, I see. So what shall we pass it over or adjourn it for the day?
No one is there, I suppose.
So if you say, we will say that Mr. Shah submits, it should be dismissed, hence dismissed. Then you face him outside court.
With Mr. Bose, I would not take that.
Not today. Not today. The appellant is not represented. Lekho. The appellant is not represented. Stop. Passing over will serve no purpose. Will stop. The matter stands adjourned for the day. Show all on one side.
That shows your Lordship that the merit is, there's no merit in that. But my junior was wondering whether your Lordship will direct filing of affidavits.
On this application, appeal has been disposed of.
No, appeal is pending.
What application has been filed?
Well, one application in the appeal has been disposed of. Nothing really survives in the appeal according to us.
What are these 2 and 3? GA2, GA3?
One is for impleadment. I think impleadment has been allowed. Oh, not moved.
GA3 has not even come to our court.
Let it be, your lordship.
They have filed GA2, GA3. If you want to file GA4, no problem. Chalo.
I appear for the appellant. So setting aside an award takes some time. Your lordship keeps it. I had started it one day, then that day Mr. Shah wasn't there. A long time.
We have all the time today because till 3:15 we are here.
I appreciate, but only half my brief has come. So my junior was saying then it can be part heard. Because it's only part of the brief. I can start.
No, up to you. If you, Mr. Shah is available also.
Up to you. It's up to you. I'd rather start and finish in one go. It won't.
All right.
I'll,
Not today.
yes. Except on Friday.
Since only half of Mr. Ghosh's brief is available today.
First volume is there.
Item number 29.
29, my lord. I appear for the respondent. Led by
Passover, what?
We are appearing for the appellant in this matter.
Yes.
My lord, if my lord permits, we have been led by senior counsel Substitution in this matter.
Permission to be led by Mr. Shakushin.
He has already concluded the matter. If my lord recollects, then we need not go into and revise, recapture the matter.
That was possible before another bench.
No,
this was 3 months back.
3 months back. We don't
My lord,
recall
it is
anything.
for not today because our senior is engaged in some.
On the prayer made on behalf of the appellant, likhe dao. Comma, the matter stands adjourned for the day.
Only one indulgence, my lord. My lord, Friday. Well, I'll seek an accommodation in the when the matter is taken up on Friday.
Very unlikely, Mr. Bose. Anyway, Fridays, this bench is available for half a day. And then we start with commercial matters. Commercial list is pretty.
For the respondent.
Passover.
I appear on behalf of the respondent. This was your lordship's last order. A peremptory chance was given to the other side to move the appeal. But, they are not moving the trial court, and they are saying that the appeal is pending here.
আচ্ছা এটাকে পেন্ডিং রেখে ট্রান্সফার এগোচ্ছে
I tell your lordship what happened in this matter.
Passover, second call, will dismiss. চলো চলো তাড়াতাড়ি ডাকতে থাকো.
33, I appear for the appellant, my lord. This is.
The other side is not here. Pass it over once.
Your lordship, on behalf of the appellant, Motilal Silva Trust.
Pass over, pass over.
Possible matter, second call. Item number 17.
ছিল না তো. চলো usual order.
Possible matters, item number 19.
Same.
Second call, possible matter, item number 30.
সেম 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 দাঁড়াচ্ছ কেন বাবা কেউ নেই দেখছো তো
Item number 35.
কি হলো সেম অর্ডার
Item number 33.
I appear for the appellant, my lord.
You want to do it, we can start, although they are not there. Who is appearing?
Mr. Suashish Sengupta is appearing.
Somebody is running towards you.
He's
33.
31.
31 and 30
For appellant.
for appellant, my lord.
It has been
Senior counsel, Mr. Abhijit
it has been dismissed. Nobody was there in the second call.
Torrential rain, my lord. We got stuck, my lord.
Can you start the appeal? Yours is not today.
My lord.
Start the appeal. Because last time we made it clear, we have recorded an order.
Yes, my lord. Mr. Mitro was there. Can I seek a very short passover, my lord? Mr. Mitro will submit, my lord.
All right.
Very short passover, my lord.
Second call, item number 34.
I am for the appellant. Mr. Ghosh is in the lift. May I ask for a short, very short passover?
Chal, Dako.
Second call. Call, item number 31. T1 32.
দাও আমাদের এটা দাও আসছে তো বললো মেমোটা দাও একটু পড়ি কি অর্ডার
I'll just give your lordship a small brief background in this matter. An ex parte ad interim order was obtained, my lord. Then we came, my lord, we disclosed everything. The learned trial court, my lord, after hearing the court, after hearing us, my lord, was pleased to vacate the ex parte order which was obtained because they suppressed prior suit which was pending with regard to this. And my lord, a reasoned order has been given. Now, my lord, in the meantime, my lord, pleadings are all complete before the first court. There is a demurrer application pending. They've been taking time out there saying appeal is pending. But wherever matter is coming up, my lord, they've been taking time.
The demurrer applications, my lord, are fixed on 21st and 22nd of August, my lord, for hearing.
Why two appeals?
My lord, because one was, my lord, their interim application has been, my lord, dismissed because there is a rejection, my lord, to that. And one was, my lord, a vacating application which was filed. My lord, against that, my lord, that was allowed. So they have challenged both.
My lord, can I only take a 10-minute passover, my lord? My matter is going on. I'm on legs. I'll come back in 10 minutes, my lord. Matter is going on. I'm on legs, my lord. I'll come back in 10 minutes and we can start, my lord.
You were on legs there?
On legs. I was told matter is getting dismissed for default, so I came, my lord.
So you left the learned judge waiting there?
My lord, the other side is saying something. So I told the judge I'll come back in 2 minutes, my lord. I just said and came back, my lord. If your lordship gives me a 10-minute passover, my lord, I'll come back, my lord. 10 minutes, I'll come back.
Your junior is here. We'll proceed. Let us read the order.
I'll come back in 10 minutes.
The memorandum of appeal is in.
So GA1 was their application.
Yes.
GA2 was your vacating
Well,
application.
it was defendant number 2 and 3 is vacating application.
You are for?
Defendant number 1. But my lord, we are all on the
Same boat. You are for defendant number 1.
2 and 3.
2 and 3.
But defendant number 1, my learned junior is okay.
One of the impugned order starts at page 400, volume 3. এক সেকেন্ড বন্ধ করো না গেছে
Yes.
Order, my lord, of the trial court, my lord, where, my lord, they have been, my lord, pleadings were all complete. We wanted to proceed because it was an ad interim order at that stage. So affidavits were completed, my lord. They sought adjournment, my lord, on the ground that the appeal was pending.
So the injunction application is pending still.
that is pending my lord.
Go
Affidavits
and
are
fight it out
complete.
there. Go and fight it out there.
There are temporary applications filed which is fixed on 21st and 22nd of August, my lord. So temporary applications has to be heard first, my lord. My lord, may I now take
Mr. Mitro is here.
I'm led by Mr. Mitro. Sorry.
Go and fight out. It is pending, Mr. Mitro.
The only
Affidavits
thing
are
is that,
complete.
Already because of this order, there are certain impacts. If the property is transferred now, that's my.
Property has already been transferred.
I have exercised the right of preemption
How have you exercised?
by immediately filing the suit. Right of preemption can be exercised only after the transfer, the wrongful transfer takes place. This is not about notice to me. The preemption right and the negative covenant here requires a prior consent to be obtained by me before transfer, or earlier an opportunity be given to me that I am going to sell this property. So, do you want to take this? That's the law of preemption, my lord. Once I get that, I have the option to not exercise, and then they can sell it. Now, my lord, this happened in June last year, my lord, June 2024. The property was transferred, and I come to know in August.
Mr. Mitro, let us tell you again. If we decide it on merits, prima facie, we have read the order and we took some time, we have discussed. We are prima facie not inclined to interfere. If you would have us pass an order, there may be comments which may not help you.
Worship, the division bench had passed a kind of some protection. Or Kelly takes a look at that order.
What protection?
That any third party rights created when it was moved for the first time, that
Lispendence, whatever the effect is, lispendence is
That
there.
order is there, page 458 of the paper book. It is that order is, kindly take a look.
At the time of admission of the appeal.
Yes.
কি আছে দেখাও তো order.
So this
Subject to
there has to be slight change in that also.
Oh, Mr. Mithru is on the other side.
Page 458. This has to be paragraph 6 of this order. Appeal will become the application in that case.
Now that we are, if you agree to our disposing and sending you back to the trial court.
Don't embarrass me by saying, because your lordship has the last say. Agree or don't agree, how does it matter?
Mr. Raichaudhuri, anyway, Mr. Mithru, sorry. Sorry, if we send it back, we don't interfere. We send it back for final disposal of the injunction application and just observe any transfer during pendency of the suit will abide by the result of the suit. That anyway it will. Suit. Issue. Where is your plaint?
The plaint is at page.
Yes, 30302 are the prayers. Yes. By consent of the parties, the
Page 32, Mala, page 32.
Page
32 starts, and the prayers are at page 39.
কেন এই তো প্রথমেই তো আছে দেখছি
32.
ও ওটা নয় কি সব দেখছি আমি By consent of the parties, these two appeals, action করবে 3031, and the connected applications are taken up for hearing together. Paragraph. দুটো appeal, দুটো application. হ্যাঁ লিস্টে আছে 3031 দুটোরই আছে হ্যাঁ The plaintiff, the appellant has filed CS number 204 of 2024 in this court against the respondents herein, claiming the following reliefs. A paper book page running page 39 থেকে 39 থেকে প্রেয়ারটা হ্যাঁ 39 থেকে 41 সেটার করে দেবে A to C, A to E. Paragraph. In short, the case of the plaintiff is that it has a right of preemption in respect of a property being
number 1 Victoria Terrace, Calcutta 17.
171 Terrace, Kolkata 17. Stop. However, in breach of such right, comma, the defendants have sold the concerned property to a third party, or defendant number 1 has sold to 2 and
Number
3.
1 has sold to the defendant numbers 2 and
In
2 and 3 or
breach of
2
such
and
right,
2
comma,
and 3.
the defendant number 1, being the erstwhile owner of the property, has sold the property to the defendant numbers 2 and 3 by way of a deed of sale dated June 28, 2024. Stop. The plaintiff has challenged such deed of sale. Stop. The plaintiff applied for interim relief.
It was granted initially.
Stop. At the interim stage, such relief was granted ex parte.
The returnable did it. It got
Stop. Paragraph.
on a vacating application. Yeah.
The defendant number 1 applied for vacating of the ad interim order. Stop. The learned single judge allowed the vacating application and allowed the vacating application. Stop. The interim order stood vacated. Stop. The learned judge directed exchange of affidavits on the plaintiff's interlocutory application.
GA1.
Being GA1 of 2025.
24.
Paragraph. Being aggrieved, comma, the plaintiff has come up by way of these 2 appeals. Stop. Paragraph. We have heard learned counsel for the parties. Stop. We are told that affidavits have been exchanged
It's a complete. It's a complete.
in connection with the plaintiff's interlocutory application before the learned Honorable First Court. Honorable First Court. Stop. We are not prima facie, we are not inclined to interfere with the order under appeal. Stop. Stop. In our view, comma, the plaintiff's interlocutory application should be heard out before the Honorable First Court.
At an
Stop.
early date, logically. Yeah. At an early date, if you
Stop. Paragraph, we see that at the time of the admission of the appeal, কোথায় বললো যেন অর্ডারটা ছিল? A coordinate bench, while declining stay of operation of the order, comma, directed that any transfer of the concerned property shall abide by the result of the appeals, and the intending transferee should be informed of the pendency of the appeals. Stop. Since we are disposing of the 2 appeals, comma, we direct that any transfer of the concerned property during the pendency of the plaintiff's interlocutory application shall abide by the result of that application, and the intending transferee should be informed of pendency of the suit and the application. Paragraph. Learned senior counsel representing the appellant oblique plaintiff says that some precedence should be given to this matter by the learned single judge. Stop. The plaintiff will be at liberty to make such a prayer before the learned single judge, who may consider such prayer according to the convenience of the court. Paragraph. Appeal and the connected application stand disposed of.
We also have an order that also
that will be heard.
Obviously, ওই একটা জায়গায় বলে দিও তো যেখানটা বলেছি, we are of the view that the plaintiff's interlocutory application should be heard out before the learned honorable first court. দেখবে একটা বলেছি একটা জায়গায় হ্যাঁ the application taken out by two application or one by the different number applications karo by the different number 1 and the different numbers 2 and 3 under order 7 rule 11 of the code of civil procedure should also be heard by the learned single judge.
Ministry to mention item number 30 I may
Item
mention
30, item 30 don't record any order bole dao
that I
not today.
It was raining cats and dogs. By the time I came running, Miller, apologize.
No, not tigers and lions.
I have a similar with regard to item 19, my lord.
19 order corona not today.
Deeply obliged.
Huh?
17. My lord,
17, 17, 17, 19.
deeply obliged, my lord.
Obliged. Job not today.
Third call, item number 34.
In appealing for the appellant, my lord, led by Mr. Shondip.
Yes, Mr. Ghosh.
Ram for the
We'll be happy to hear you for 8 minutes because there's a full court reference today.
Yes, yes.
So we will rise at 3:15.
I don't think I will. Let me start.
Start.
Well, on the last occasion, this order has been passed in an application under section 78 of the Trust Act. Well, as your lordship knows, the Motilal. Your lordship knows, Motilal Seals Trust. There are 4 branches in the trust. The trust deed was executed way back in 1947.
Other matters released for the day.
Actually, your lordship had asked for the affidavit. We are ready with the affidavit. Only that much I wanted to indicate. The other side is also here. The affidavit which was called for. This is the matter where
Yes. Yes.
it was in relation to sale of the cargo.
Mr. Ghosh, let us not start today then because it will serve no purpose.
Absolutely.
Not today.
But I will take at least 15-20 minutes time.
পরেরটা ডাকো
No issue.
ওই এটা কোক 10,000 টন কোক এটা কিছু করতে হবে ব্যবস্থা
ওপেন করি শেষ করা যাবে না
My lord, your lordship.
সময় লাগবে না
You are led by no, you're not Mr. Bose.
Mr. Bose is there. I'm told he's engaged in court number.
Who is you are the OL.
My lord, the affidavits are ready. May I be
You are Sharad Chatterjee.
Yes, Sharad Chatterjee, the handler.
আগের দিনের অর্ডারটা দাও You are LMJ.
You would like to use an affidavit. Yesterday we got an affidavit from.
No, let us see. It was affidavit. We wanted some information.
68 documents which have been annexed to substantiate the
This is only in order to substantiate our
that way
contention.
we have
What is the amount that we have spent with regard to the port charges?
Madam,
Only what was
my
asked for,
case is
along with
that
the particulars.
The claim which they are raising is exorbitant and not as per the agreement. We have to analyze and sit with
This
the
is what
client
has
to
been
see
going on, my lord. That is the reason why the
if
sale has
we
not
make
taken
60
place.
documents and we will not get the chance to
They already knew it
How do I get the affidavit?
because all the documents, the affidavit The affidavit contains all the contemporaneous records exchanged between the parties. If my learned friend makes such a submission, then he should also take responsibility because the annexures show that they are all contemporaneous records.
Maybe, but we have to deal with now it is brought on
Apart
record
from
before the court.
apart from denial, I don't understand what my learned friend will bring on record.
So please don't make a comment on what I'm going to write. I have to sit with the client and see what is the document.
This is what has been going on.
Not at my instance, at your instance.
Issue. Affidavit filed by Sharad Chatterjee and Company bracket VSP দেখে নিও নামটা Private Limited be taken on record. Stop. Paragraph. Learned advocate for LMJ learned senior advocate.
Respondent number 2 is better because the name has now changed. Respondent number 2.
Oh, learned senior counsel. All right. Learned senior counsel representing the respondent number 2 seeks a little time to file a response to the said affidavit. So let such response be filed within a week from date. Date to the other. Paragraph list the matter list from week from date with advance copies to learned advocates for the other parties. Paragraph list the matter 1 week hence.
Contemporaneous records.
Date to the other. Cholo amra jai. Do you wish to file an affidavit, Mr. Bose?
Sir, your lordship only directed me to file.
Correct. They are saying you have raised inflated claim.
Yes, that was our
They have been saying the same thing.
Well, they have been saying this even before.
They have indicated it was supposed to be 11,000 something.
Again, the same one.
Subject to a lordship instruction from my client, I will be also using that.
Sale, shono.
Only one thing.
Learned counsel for the respondents. You are appearing.
Yes, yes, sir. One.
First time we see him in this matter.
Yes, he was 10 years inception. March in between he was not there. Lordship,
Come back next Wednesday.
the architect of everything. But
Next Wednesday.
Next Wednesday. 6.
এই রত্নাঙ্ক ব্যানার্জির নামটা রেকর্ড করে
আমি দেখিনি তো
কত নম্বর রেস্টুরেন্ট আছে আমরা একটা এলএনজি ওদের হয়ে